Hello, everyone. Welcome to the Prof Show. We are here tonight on this late night show to cover the Richard Allen appellant's reply in the Delphi case. So please prepare for a long night. Get yourself some refreshments and relax. And let's take a deep dive on into this filing. I think you'll find it very interesting, and I'm glad to see everyone. So just give me a moment, and we will be starting. Okay, and welcome into Tuesday, April 28th, 2026. Boy, has it been a long day. I got to tell you, it has just been a whirlwind of a day. I hope everyone's doing well. I want to say hello to everyone in the live chat. Um, Everyone in the live chat, we appreciate seeing you here and thank you for your participation. Please feel free to just run amok in the live chat. Let us know what you think. Let me know what you think. Keep me up to speed on your thoughts because you know you're going to be getting mine here. And also those of you on the replay, I'm so fortunate to have you here on the replay. So please do leave your thoughts down below in the comment section because I don't want to miss anything. As long as you're not abusive, all opinions are welcome. And on that note, I want to say this. There are many of you who have been a little butthurt over the years and have stopped participating in the channel. And I want to extend this open invitation to anyone who's ever been butthurt, who I've ever offended, who we've ever bumped heads. Look, we have a lot more important things to deal with than personal issues here. These are extreme constitutional issues we're addressing here. We're also addressing the brutal murders of dozens of children in the Midwest, particularly the two little girls in Delphi, the four in Flora, and the two in Evansdale. And this is serious business. So I would like to welcome everyone to come back and join this community. Join the live chats and the comment sections, but do not be abusive to anyone, including myself. We won't tolerate it. But I have sensed in the past year the extreme amount of personal vendettas and grief and anger out here that has been created by bad actors on the internet. And please do not let that get in your way of pursuing justice for Abby and Libby. Those of you who are die-hard Delphi followers, I think we need to get over ourselves and focus on what's important here, and that's justice for Abby and Libby. And unfortunately, at this point in time as well, it's justice for Richard Allen and his family because he's been caught up in all of this. So please do uh, reconsider your grievances and focus on what's important. And this tonight is very important. Um, but with that being said, I'm going to let you know that I have been working all day. I woke up this morning after getting no sleep last night, expecting to have this filing appear. And lo and behold, it happened. And so my initial several hours of work was in studying the document. And then I had several more hours of work of researching. And then had several more hours of work with publishing a series of articles on Substack, uh, presenting a balanced, unbiased view of this entire appellate situation. And now tonight, after a brief rest period, I'm going to spend several more hours um, going through this methodically with you guys. So this has, it's going to end up being a 16-hour day, but it has been a hell of a day. But I would like to thank you all for being here, and we're going to dive right on into it. And I'm going to try to, what's the word? Patiently go through all of this. Because of the rush today, there's been a lot of impatience because I've been trying to frantically push this all out. But with that being said, now I get to slow down, kick into a higher gear and or lower gear, which is it? But I get to kick on into a more slow pace, and we're going to patiently go through this. And this is especially for those of you who get a little confused by reading these documents. There are also, let's be honest here, this platform here, I do not platform state actors, okay? I do not platform bad actors. So you might be out there getting your ear full, but you might be getting a bunch of bullshit, distraction, and gaslighting. So be assured that tonight you will not get that with this thing. We're going to methodically and patiently go through this, and this will just be our first look. Essentially, this is an introduction to the appeal of Richard Allen. Now, we've already been through the initial filings, but now that we have everything, all the cards laid out on the table, this is going to be the introduction to our series on the entire appeal of Richard Allen. And that's what we're doing. So, so on that note, I got to tell you, the thing I was absolutely most excited about today was this, okay? And that is the motion for oral argument, okay? So for all of you out there who are interested in this case, this should be the most celebrated filing that we have, honestly. And I'll explain why in a moment, but let's quickly go through this so you can understand the motion for oral argument. It says Richard Allen by counsel Lehman and Uliana respectfully request the court to schedule this case for oral argument. In support of the motion, Allen states the following. The case is factually complex, true, spanning 22 volumes of transcript, 15 volumes of electronic exhibits, and multiple volumes of conventional exhibits. An oral argument will put facts in context and answer any questions, which is essential. This also involves an issue of first impression, whether Allen's statements made during a period of psychosis caused by his prolonged maximum security solitary confinement were voluntary and admissible. This case also involves the important constitutional issues of rights to present a defense. Wherefore, appellant by counsel respectfully request an oral argument. Okay, certified on April 27th, 2026. So what's so special about this? Well, I'll tell you what. I need all of you out there to put your thinking caps on and remember one thing. And that is when our insane and biased judge, Francis Gull of Allen County Superior Court, decided to obscenely pressure Richard Allen's defense attorneys to recuse themselves or to step away or to step away from the defense of Richard Allen, advocacy for Richard Allen. When she did so, and this case ended up in front of the Supreme Court of Indiana, I would urge you to remember that Mr. Mark Lehman was the deciding factor in that outcome, which was that she was forced to reinstate Baldwin and Rozzi because of her egregious behavior. Okay, so what that means, and what I'm telling you, is that when I went and I viewed those oral arguments in front of the Indiana Supreme Court on that issue, I was highly impressed with Mr. Mark Lehman, and I made that known at the time. Actually, what I did, as far as I remember, is I remember downloading the video of said arguments and producing a transcript, and then I remember going through that transcript meticulously to point out to you how Mark Lehman knocked it out of the damn park, and he was the deciding factor in compelling the Supreme Court to do the right thing. So I guess my takeaway is that if he has the same opportunity to advocate for Richard Allen orally and answer questions and present context to all of this, it will exponentially increase the odds of a good outcome for Richard Allen. And that's what I got to say about that. Okay. All right. So it looks like there's a little problem in the chat with Mr. Author being accidentally, let's see, hidden. Let me take care of Mr. Author. Okay, Author, you're good, Author. I think you're back. Okay. All right. Sorry about the problem with Mr. Author being accidentally muted there. Okay. All right. So that issue is solved, and no one criticized Deb. She's the best mod in the true crime community, and that's for sure. Okay. So I guess I gave you my opinion on the most exciting aspect of today's filings, which was this motion for, what do you call it? Oral arguments. And I would expect that we'd have Mr. Lehman again step to the plate and knock it on out of the damn park, because he certainly did so in front of the Supreme Court of Indiana on the prior occasion. And so with that, I want to tip my hat in respect to Mr. Mark Lehman and acknowledge his great performance in that hearing. And I anticipate another great performance out of him given the opportunity. So Now, that's the good news. That's the good news. The bad news. So, my initial impression today upon reading all of this is that the bad news is this filing was less impressive than I expected. Okay. Um, but it's twofold. Okay. It's less impressive than I expected because I expected something as impressive as the first. Um, so it was somewhat of a letdown that it was less impressive than I expected or anticipated. However, there is a secret here. There's a key. And the key is that when it comes to this particular brief, the devil is in the details because overall it is less impressive than I anticipated. However, there are certain pieces in the minute details where the state's gaslighting ass arguments are thoroughly deconstructed. And when we get to those details, I'll try to point out to you where those are. So it's sort of an interesting, it's a catch 22 and two sides of a coin, I guess. Less impressive than I expected, but still containing the necessary elements in the details to deconstruct the state's poor arguments on this case. Okay? So that is my situation. That is what we're getting into tonight. And that's what you can expect for the next however many hours it's going to take us to go on through this. So, yeah, let's get into it. There's not much further ado to go on about. I think it's probably a record for us to be 17 minutes in, and we're 17 minutes in, and we're getting started. So yeah, I'm improving my rate by 3 times over. Yes. So here we go. So you guys will remember that there are several aspects of the initial filing. And quickly, let me see if I can refresh our memory here, or my memory, as to what those were. Oh, let's see. Here we go. So the initial issues were the following here. Let's get into it. So you'll see that the issues they are raising initially were 3. And that was whether the search of Allen's home was unconstitutional, whether the unprecedented pretrial solitary confinement produced confessions that were involuntary, and whether the court or Judge Gold denied Allen his right to a fair trial and to present a complete defense, and additionally to impeach the investigation. So, so let's take a looky at this here. So you see here, unconstitutional search, that the court committed reversible error by admitting. How about I do this? Just a moment. Okay, I'll do it this way. All right, so let's get into this. That the trial court committed reversible error by admitting evidence obtained through an affidavit built on deliberate falsehoods and material omissions. Detective Liggett falsely swore that witness Carbaugh gave an incriminating description in 2017 and that Allen admitted wearing matching clothing. Neither was true. Detective Liggett simultaneously concealed Blair's eyewitness descriptions, which excluded Allen and his vehicle. Okay, and that's an important thing. So what I'll do here is I'll highlight this for you. Okay, he simultaneously concealed Blair's eyewitness descriptions, which excluded Allen and his vehicle, withholding from the judge the very evidence ISP had validated in a 2019 press release. The pattern is unmistakable. And here's another one. Every fact undermining Liggett's theory was omitted. Every fact supporting it, however, distorted, was included. Okay? Strip away the falsehoods and restore the omissions, and probable cause does not exist. Because Allen exhaustively litigated suppression below, his challenge is preserved. Okay? So I hope everyone can understand what's being said there. So that by concealing Betsy Blair's description, which included Allen in his vehicle, and withholding from the judge that the evidence ISP had validated in a 2019 press release, was that Guy A was not Guy B. Guy A had been cleared, and Guy B was the person of interest. Detective Liggett withheld that from the judge, and it's unmistakable that every fact that undermined his targeting of Richard Allen was omitted from this probable cause affidavit, and every fact that he could twist and bend to support it or distort it was included. And the takeaway here is that if you strip away these misrepresentations and falsehoods and restore the omitted information, probable cause does not exist. Okay, now moving on to the unprecedented pretrial solitary confinement. It says the trial court committed reversible error by admitting confessions the state extracted from a man it broke. Law enforcement interrogation is not required for coercion. Again, listen to this. This is the key legal bar that must be reached, okay? Because this was something not Nick McClelland, but essentially McClelland, the state falsely argued that law enforcement interrogation was required for the coercion to be considered as coercion. But that's factually wrong, and we're going to look into that tonight. You're going to see that tonight. Law enforcement interrogation is actually not required for coercion, and we're going to explore that later tonight. Prolonged solitary confinement on a very severely mentally ill detainee plainly qualifies, especially where law enforcement, upon learning of the inmate's grave disability, doubles down and starts, look at this word, collecting confessions. The state's attempt to reframe Allen's 13 months of maximum security isolation as routine custody cannot be reconciled with the IDOC's own policies, the IPAS litigation, or the unprecedented harshness of Allen's confinement. The state failed to prove beyond a reasonable doubt that Allen's confessions were a product of irrational intellect rather than their deliberate indifference to his mental health. Again, the state failed to prove beyond a reasonable doubt that Allen's confessions were a product of a rational intellect. Okay? So you see, we've hit the two major first pieces of the initial appellate filing, and now we're going to move on to the third component here, which is the unfair trial. A criminal defendant has a federal and a state constitutional right to present a complete defense. Okay? Evidentiary rules that exclude critical defense evidence on grounds disconnected from the rule's purpose violate that right. Holmes versus South Carolina. The trial court's rulings on 7 categories of defense of evidence violated that right. Now, let me see if I can pull up this, which I have highlighted for you. Let's see. Come on, Prof. This will make it easier. All right, let me grab this. We're going to multitask and kind of hit it in different ways tonight. All right, check this out. This is what we're looking at, okay? Notice what I've highlighted here. I'll blow it up for you guys. Okay, so the 7 components are the sketch, the ritualistic explanation, the scientific critique of the firearms or ballistics, the evidence implicating Brad Holder and Patrick Westphal, law enforcement's failure to investigate them. It also never heard the audio of Allen's psychotic episodes, which was essential in determining his mental health. Also, the book-ended calls and clinical observations that would have impeached his confessions, or the unimpeached phone data that contradicted the state's timeline. So if you count there, you have 7. 1, 2, 3, 4, 5, 6. And I forgot to highlight the 7th, which were the phone calls. Okay, so let's go back to this. Let's see. All right, so let's see if we can highlight them here. Okay, so what we got here, sketch. Okay, I'll help you guys. The sketch, the ritual explanation, the unreliable ballistic methodology, the 2 suspects, Brad Holder, Patrick Westphal, audio of Allen's psychotic episodes, the calls before and after the April 3rd call, unimpeached phone data that contradicted the timeline. Okay, so let's count them again now that I'm able to count here. Let's go 1, 2, 3, 4, 5, 6, 7. Now, what does it say here again? Let's back it up. It says the state's brief argues at length that the evidence against Allen was overwhelming. Where does it say 7? Hold on. Oh, here we go. This is what I meant. The trial court's rulings on 7 categories of defense evidence violated that right. So let's put this together now. So when it comes to the evidentiary rulings that require remedy, they are pointing out these 7 specific rulings of Judge Gull. This is what I'm trying to get across to you guys. So the 7 that they are specifically pointing out, the 7 rulings of Judge Gull that are most egregious that they are pointing out are here. The ruling on the sketch of Betsy Blair, the ruling on Dr. Perlmutter's ritual explanation of the crime scene, the ruling on Dr. Grazian's opinion of the unreliable methodology for the ballistics, the ruling on the 2 alternative suspects, which is the investigation into Brad Holder and Patrick Westphal. They're also pointing specifically at the audio which was attached to the video of Allen during his psychotic episodes. You notice what happened in this court is that they disallowed the audio to be included. So how is that fair? You're going to play video. Why not allow the audio video? Because Doesn't video normally indicate AV, audio video? But what they did is they muted the video, they muted the audio, removed the audio from the recordings of Alan during his psychotic episodes to make them less compelling. So by removing the audio from the video, you gave the impression of fairness by showing the video, but a large portion of the psychosis was evident in the audio, the things that he was saying and doing. Okay. Also, with the phone calls, it was very unfair to present the phone call in isolation without the context, where he had a phone call before, a phone call after, and they only chose the phone call in the middle. And you're going to learn tonight that in the phone call before, he was questioning his sanity. In the phone call after, he was questioning reality. And they say that neither of those things happened. We're not going to, those don't matter, because he was lucid and operating of his own free will and voluntariness when he gave this confession in the middle of all that shit. In other words, he's questioning his sanity, his lucidity. Okay, in one, that's omitted. He makes a confession, quote unquote, in the middle. That's allowed. And then he questions reality and whether he just had a nightmare or not in the following one, and that one's omitted. Okay. So I'm showing that the book-ended phone calls that she disallowed, and clinical observations. And again, the unimpeached phone data that contradicted the state's timeline. Each ruling was reversible error. Reversible error. Each ruling, each of the 7. Together, they kept Allen from setting the state's case ablaze and denied him a fair trial, which is essential. That's the whole purpose of appeals. The whole purpose of appeals. You have the right to a fair trial. Remember that right? The right to a fair trial? It does exist, allegedly. Question here for the retards in the back. Oh, so sorry, I use bad words from time to time. I apologize again. I just would like to point this phrase out to you. But the state's case was a paper tiger. Paper tiger. Paper tiger. Okay, I'm going to note that. I'm going to note that. Make a mental note of that phrase and we'll continue. I'll talk about it later. Okay, so compounding these errors, the state knowingly presented false testimony from Brad Weber about when he arrived home the day of the murders. Testimony. The state's own FBI subject information sheet refuted, and then exploited it in closing as an act only the killer would know. Allen attempted at least 6 times to correct this falsity, and the state obstructed every single attempt. And this is what is called as the Napui claim, okay, requiring reversal. And we'll talk about that later when we get into my Substack articles. All right, we're going to move on. Now we get into the details, okay? So you kind of got a double-edged sword here in this next argument. It says the trial court committed reversible error by admitting evidence seized from the unconstitutional search and denying a Franks hearing, okay? 2 sides, double-edged sword here. One side of the sword is that fruit of the poisonous tree. The other side was you didn't give the Franks hearing. Okay. So let's look at it. Allen's exhaustive pretrial litigation preserved the Fourth Amendment issues. Okay, the state contends that Allen waived his Fourth Amendment challenge by stating no objection when individual exhibits were offered at trial. Okay, and remember I told you when the state filing came out, I said that's absolutely false. Okay, that's absolutely false. They can't do this after the fact and say he did not object. Okay. So let's see. Next up here, it says the argument fails on three independent grounds. First, the purpose of the contemporaneous objection rule was fully satisfied. The overriding purpose of the requirement for a specific and timely objection is to alert the trial court so that it may avoid error or promptly minimize harm. Okay. Courts should not apply the rule with unyielding rigidity when this purpose has been met. And here it's going to explain this for you. What it says is Allen's attorneys exhaustively litigated the suppression, filing multiple motions supported by more than 130 exhibits. After the court denied the motion to suppress without a hearing, Allen renewed it twice more, which again the court denied. Throughout the extensive briefing, Allen repeatedly emphasized Liggett's omission of Blair's description and the falsehood about Carbaugh. Allen did not idly sit by only to cry foul when the court ultimately renders an adverse decision. Okay, so you see what I mean by the reasoning here for these objections should be when you have an individual who only cries foul, who only objects after the fact when the court ultimately renders an adverse decision. But that did not happen in this case. And you're going to see specifically why momentarily, because they literally spell it out for us. There's no strategy for Allen's attorney's failure to object to evidence so that they so aggressively litigated. For judicial efficiency, the issue should be resolved right now rather than in post-conviction relief. Second, the recent amendment to Evidence Rule 103B confirms that Allen's challenge is preserved. The Indiana Supreme Court amended the Rule 103B to clarify that once a court rules definitively on the record, either before trial or at trial, a party need not renew an objection or offer of proof to preserve a claim of error on appeal. Okay, this includes a ruling on a motion in limine. And look at this. This was effected on March 6, 2026. Okay, look at the date there for you guys, please. We are now April 28th. Okay, we're now in April 26th. April 28th. This rule is in effect that once the court rules definitively on the record, either before or after trial, or before or at trial, a party need not renew objections or offers of proof to preserve a claim for error, for appeal. That's as of March 6th. Now, what's interesting here is they go on to elaborate that the state urged the court to ignore the amendment because it was not in effect at the time of trial. But because the rule governs what is required on appeal, you see, it should be applied to Allen's pending appeal. Keyword there, pending. At a minimum, the amendment reinforces the DRC principle that the contemporaneous objection rule must not be applied with unyielding rigidity. In other words, this rule favors the accused. It does not favor the state or the court. This would indicate an intention to balance the due process and the course of justice for defendants or accused, in that they're not being handled, and here's a term right here, with unyielding rigidity, especially in this case. All right. Thirdly, the Franks hearing denial is a pretrial constitutional rule requiring no trial objection to preserve. The trial court did not merely admit evidence, it refused to hold a Franks hearing. Okay? It refused to hold. She refused to hold a Franks hearing. Once the ruling was made, no further objection at trial could undo it. The state cited no authority requiring a defendant to object at trial to preserve a denial of a Franks hearing. See? So is that clear to everybody on that point there? Hope so. Hope so. So let's continue because now we're going to get to that other side of it, which is that Detective Liggett included multiple deliberate falsehoods in the affidavit. And boy, it's going to get spicy here. Detective Liggett included multiple deliberate falsehoods in the affidavit. The state argues that Liggett's representation of Sarah Carbell's account that she reported seeing a muddy and bloody man wearing the blue collar jacket was not a false statement, and that any inaccuracy may have been a mistake. This argument also fails. Liggett did not just represent what Carbell said, he represented when she said it. Okay, so I wanted to show you that because this is, let me bring myself back up here. This is one of the points, one of the minutia where I said the devil is in the details. Okay, so in this particular argument, it's really pertinent to understand the distinction here. Now listen, you should have noticed by now a pattern with Nick McClellan, with Jerry Holman, with Tony Liggett, with Francis Gull, and this entire contingent of people who railroaded Richard Allen. And the whole deal is, you could call it throwing the baby out with the bathwater or painting with a broad stroke. Okay, either way, they always do things in this way, which obscures the fine detail and the true meaning in what's being argued, and they paint with this broad stroke of a brush, or they throw the baby out with the bathwater, which is what's going on here. Because there's a distinct difference here. There's a distinction between Liggett. So they say it wasn't a false statement. However, Liggett didn't just represent what she said; he misrepresented when she said it, swearing that she gave her description in 2017. That's where it's important. Okay, that's where this particular point right here, I was very impressed with this sentence that you see highlighted. Liggett did not just represent what Carbaugh said. See, they even bolded the word. He didn't just represent what she said, he represented when she said it, swearing that she gave her description in 2017, which is false. The temporal representation added a veneer of reliability. That's why they did it, to paint with that broad brush, you know, because a description given close in time to the murders carries obvious weight. The state concedes that in 2017, Carba never described the man as bloody or as wearing a blue jacket. Okay, in 2017, she described him as muddy and wearing a tan jacket. And we all know that at this point in time. We know that by now. So that's an important distinction here. In 2017, the time closest to the murders, she described the man she saw as muddy in a tan jacket. Okay, so when Liggett misrepresented it, which is putting it nicely, he misrepresented what she said and when she said it. Swearing, again, it says here, swearing she gave her description in 2017. Now, like we've all said before, the evolution of Carbell's statements made the affidavit more misleading, not less. In other words, that Carbell's account change over the years from muddy to muddy and bloody and from tan to blue. I mean, isn't that obscene? You guys don't find that obscene? That she changed from muddy to bloody and she changed from tan to blue? And she only did so after seeing the photography of a man in a apparent blue jacket. And she fantasized that he was bloody to make her statement believable that she saw the man in the photo or in the video of Bridge Guy. She wanted to add weight to her allegation that she saw that Bridge Guy. So to add weight to it, she changed her story from muddy to bloody. So let me ask you. Let's say someone's looking at you and saying, "Hey, uh, I'm accusing you of being Bridge Guy. I think I saw you." And you later discover that this witness's initial statements were that you were muddy in a tan jacket. She saw a muddy man, you in a tan jacket. You were muddy in a tan jacket. And years later, after she's become very familiar with the Bridge Guy imagery, she suddenly changes that to, "No, I saw him. I saw a Bridge Guy. I saw a guy in a blue jacket who was full of blood. He was bloody. He was all bloody, 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 17 times, I think it was." Okay. But that information is precisely the kind of information that the issuing judge, Judge Diener, needed to assess her reliability. It was context, and it would have been truth. Police officers seeking a warrant should provide the magistrate or trial judge with all information at their disposal concerning a source's reliability. Instead, Tony Liggett only included the version of Carbaugh's account that fit his conclusion, and he falsified when she gave it. Now, guys, that is not slander. That is not defamation. That is not falsely accusing him of lying. Understand what you're looking at here. This is in black and white. This is fact-based, and this is backed up by all of the evidence. Tony Liggett, sheriff at the time, falsified when she gave her statement, and he altered her version of the account to fit his predetermined conclusion that Rick Allen was guilty. It's also implausible that Liggett made an honest mistake. Liggett was the officer who interviewed Sarah Carbaugh in 2017. Is it making more sense now? He was the officer who she gave this statement to. All right, moving on. Liggett also omitted that Betsy Blair did not believe she saw the same man Carbaugh did. As a matter of fact, she was adamant. As a matter of fact, Betsy Blair was adamant. Remember, all the way to 2019, she was adamant that sketch of the old Bridge Guy was not the person she saw. In fact, she was angry. She was angry about that old guy sketch and said they needed to use her sketch of the young guy because that was indeed who she saw. And as a matter of fact, all of this consternation resulted in a 2019 ISP press release that the man Sarah Carbaugh saw was not Bridge Guy. Okay. And what we're going to do now, we're going to take a little detour because you deserve it. I owe it to you. Just a moment. I'll try to get it right here because I owe this to you. It's essential that everyone see this. And those of you new to this case, if you don't know about this, this will make your head explode, and this should change your mind forever, especially all you guilters out there. If you're a true guilty, if you think Rick Allen is guilty because the state told you he's guilty, let's just take a look at this right here. It's going to take me a moment to get it because I didn't have it preloaded. I messed up. Okay, here it is for you. Let's take a very close look at this. Multi-agency task force clarifies points about the Delphi murder suspect sketches. April 24th, 2019. Okay, it says multi-agency task force. In the early days and months of the Delphi murders investigation, information was developed about suspect descriptions. It was initially believed that the sketch that has been public from 2017 to 2019 over the last 2 years of a person in the age range of his 40s to 50s was a person of interest in this murder investigation. Here's the important verbiage. Now, as the investigation has matured and past information has been reassessed, it is the belief of investigators with the multi-agency task force that the person depicted in the sketch released on April 22nd of 2019, which is the young guy sketch, more accurately represents the person wanted for murders of Abby Williams and Libby German. It is important to distinguish these points about the two sketches. And this is from Indiana State Police. This is Kim Riley. This is not the prof. It is important to distinguish this fact about those two sketches. In other words, Sarah Carbaugh versus Betsy Blair. Let me clarify that for you. This is giving you factual statements from the Indiana State Police and investigators with the multi-agency task force regarding Sarah Carbaugh and Betsy Blair, who they witnessed. And what it says is they are not the same person. They are not the same person. First bullet point. They are not the same person. It goes further. The person depicted in the originally released sketch, the old guy, is not presently a person of interest in this investigation. The sketch released on April 22nd, the young guy sketch, is representative. That means Sarah Carbaugh's person is not presently a person of interest. They are not the same person. Betsy Blair's sketch, not the same person, is representative of the face of the person captured in the video on Libby German's phone as he was walking on the high bridge. The person in the sketch, released April 22nd, the young guy, is described as having a youthful appearance, but could fall in the age range of his 20s to late 30s. This person's appearance could look different today if he's grown a mustache, beard, or let his hair grow longer or cut his hair shorter. Members of the Delphi community should reflect back on people they know in the community that look similar to the young guy sketch, who's not the same person as the old guy sketch, who's not the same person that Sarah Carbaugh saw. So you tell me, how does this make any sense? How does it make any sense? How do investigators suddenly target Richard Allen and delete this from reality? Blair and Carbaugh, it's no coincidence that the false statement and omission both bolster Liggett's new conclusion that Blair and Carbaugh both saw Bridge Guy. The Carbaugh falsehood is not the only one in the affidavit. Sorry. Oops. Here we go. The state does not dispute the fact that Liggett falsely stated in the affidavit, written the same day Allen was interviewed, that Allen admitted wearing a black or blue Carhartt. In fact, Allen told investigators he did not know what he was wearing that day, which means, again, Tony Liggett falsely stated that Allen admitted wearing a black or blue Carhartt. He did no such thing. He told them he didn't know what he was wearing. Even if Allen did not argue this specific falsehood in his briefing below, this court may consider it in response to the state's appellate argument that Liggett simply forgot, quote unquote. The common thread is plain. Liggett's affidavit forgot every single fact that did not fit his theory that Richard Allen was bridge guy. Important, very important there. Tony Liggett, let me bring myself closer here. Tony Liggett forgot every single fact that did not fit his theory that targeted Richard Allen. Furthermore, Betsy Blair's omitted descriptions were made with reckless disregard for the truth because they directly negated the warrant's core finding that Allen was bridge guy. While the state concedes Liggett omitted, state concedes that Liggett omitted parts of Blair's identification, excluding Allen or his vehicle. The state argues that Allen failed to show these omissions were made with the requisite intent to mislead or with reckless disregard for the truth. The state is wrong on both the law and the facts. The state, in fact, misreads State v. Allen as holding that intent to mislead cannot be inferred from omissions themselves. But the case rejected the proposition that any omission shows such intent, not that a material omission cannot support that inference. Settled Indiana law provides that omissions are made with reckless disregard for the truth. Here we go. When an officer withholds a fact in his ken that any reasonable person would have known was the kind of thing the judge would wish to know. Okay. An officer, Tony Liggett, withheld facts that any reasonable person, including the judge, would wish to know. Betsy Blair's omitted descriptions were exactly the sort of thing that any judge or reasonable person would want to know. In fact, Betsy Blair's descriptions directly undermine the affidavit's central conclusion that Richard Allen is the individual on the bridge. Tony Liggett swore under oath that he was able to, quote unquote, corroborate information that Allen was at the trails at the same time as Libby and Abby were, and that the individual in that picture on Libby's phone matches the description of Richard Allen. But Liggett knew that Blair, the only witness who was on the bridge, right? The only witness who was on the bridge at the same time as the man, allegedly, described someone who did not match Allen. She also described a car that did not match his car. Remember the 1965 Mercury Comet. He withheld that contradictory evidence while including portions of other witness accounts that supported his conclusion that Richard Allen was bridge guy. The selectivity was not neutral. Liggett included every description pointing towards Allen while suppressing those excluding him. And that's a key point, I believe, in this paragraph here. That Tony Liggett included every single description that pointed towards Allen and suppressed every single description or fact that excluded Richard Allen. Had Betsy Blair described someone who looked like Allen or his car, there's zero doubt that that description would have been front and center in this affidavit. The state contends Blair's descriptions are immaterial because the timeline is so tight that Allen had to be bridge guy. That's an assumption. You see how facts versus assumptions come into play in the court of law? Okay? That Allen had to be bridge guy regardless of Betsy Blair's account. But that argument assumes its own conclusion. The tight timeline holds together only if Blair's account is set aside. The fact that the only eyewitness who definitely saw a man on the bridge described him and the nearby car in ways inconsistent with Allen and his vehicle is precisely the type of information a neutral magistrate would want to know before issuing a search warrant. Without the falsehoods and with the omissions restored, the probable cause evaporates. The state's probable cause theory rested on three pillars: right place, right time, right clothes. Okay? The clothing connection. The clothing pillar falls first. Liggett tied Allen to Bridge Guy through clothing 11 times in the 4-page affidavit, twice falsely representing that Allen admitted wearing matching attire. That was false, okay? In reality, Allen said he did not know what he was wearing that day. He allowed he could have worn a blue or black jacket, but also a hoodie or sweatshirt. The blue or black jacket was the glue holding the state's timeline together. Strip away the fucking blue or black jacket. That is false. And that Allen admitted wearing it, and the clothing connection dissolves. So the clothing connection's gone. In other words, this has deconstructed Liggett's Tony Liggett's clothing connection. Okay, next, the timeline. Blair's omitted descriptions of both the man on the bridge and the vehicle in the CPS lot directly contradict the state's timeline theory. Even the state acknowledges that discrepancies between Blair's description and Allen's appearance might be significant to the existence of probable cause. Yet, the state offers no reasoned basis for setting Blair aside. Blair is not peripheral or unreliable. She is the only person who unquestionably saw the man on the bridge, and the ISP itself validated her account and the sketch in that 2019 press release we just read. Liggett hid that validation from the judge. Allen also never, quote unquote, placed himself on the bridge at the same time Blair saw Bridge Guy there, okay? 2 days after the murders, Allen told investigators he was at the trails from approximately 1:30 to 3:30. 5 years later, he said it was around noon to 1:30. Similarly, the Harvest Store video shows a car whose license plate and driver are both unidentifiable. And that goes, by the way, especially for all of those of you who are new here, this goes for every single vehicle on that Harvest Store footage. So when it comes to the entirety of the Harvest Store footage, not a single vehicle can you determine the driver or the license plates. Even if the car were Allen's, Blair's testimony that the car in the CPS lot was not black and had sharp angles, okay, not black. So Betsy Blair, your crucial witness here, Betsy Blair, says the car is not black. What color is Richard Allen's car? Black. Betsy Blair said the car had sharp angles like a 1965 Mercury Comet. What kind of angles does Richard Allen's car have? Round. Okay. Stripped of these falsehoods and supplemented with the omissions, what remains is this. Allen took a walk on the trail in the early to mid-afternoon on the day of the murders and owned a jacket that could have been blue or black. That's not probable cause. And by the way, for those of you who are new also, he did own a blue Carhartt jacket, which the state twisted and tried to frame as the jacket the murderer was wearing that day. But that jacket that he owned, that blue Carhartt jacket, was purchased for him by his wife years later. And there's proof of that fact. This is not assumption. This case is nothing like Ware v. State, involving law enforcement who omitted an earlier eyewitness identification after excluding that alternative suspect through forensics. They had independent evidence supporting the warrant despite the omission. Here, there was no independent evidence linking Allen to the crime. Not one tip or witness identified Allen. Do you guys see that? Do you guys see that? Not one tip, not one tip, not one witness identified Richard Allen. As the Indiana Supreme Court has recognized, a neutral and detached magistrate, not a police officer, makes the determination of probable cause. That's killer right there, right? A neutral and detached judge, not a cop, makes the determination of probable cause. Because police officers are often engaged in the competitive enterprise of ferreting out crime. Law enforcement cannot simply omit information that casts doubt on probable cause. All right? So this is good. This section here, honestly, this is one of the better sections. This section is good here, okay? In my opinion. So let's continue. The appropriate remedy for improper denial of a Franks hearing is reverse and remand. Okay. The state erroneously argued that there's no remedy for or harm caused by the trial court's failure to hold a Franks hearing. However, courts have consistently reversed and remanded for a Franks hearing, which honestly, let's be real here. This is probably your most likely outcome in this case. Most probably, your most likely outcome is reversal and remand for Frank's hearing, which should have occurred in the very first time it was asked for. Okay. The state's own argument demonstrates harm. The state contends Allen failed to prove by preponderance of evidence that Liggett's omissions and falsehoods were intentional or reckless, but that is precisely the showing a Franks hearing is designed to allow a defendant to make in person through confrontation with full evidentiary development. The state cannot simultaneously argue that Allen fell short of his evidentiary burden and that he was not entitled to producing to the very proceeding where that burden is tested. A defendant is not required to make two proffers, one to secure a Franks hearing, another to demonstrate what he would have proven at the hearing. Franks and his progeny require no such thing. Ruling for the state would nullify the constitutional protection Franks established. Now, that's an important sentence there. Okay? Important there because this becomes a constitutional violation. Again, emphasis for those in the back. Ruling against this reversal and remand for Franks would nullify the constitutional protections offered by the Franks process, okay? Allen proffered statements from Blair, Carbo, Allen, and his wife, and identified specifically how each contradicted the warrant affidavit. That proffer, at a minimum, called the warrant's validity into serious question and entitled Richard Allen to a Franks hearing. Allowing the state's procedural argument to prevail would mean that any defendant whose Franks challenge is improperly denied before trial has no meaningful remedy after conviction. And here's a precedent, okay? This is a precedent-setting ruling. This is why this appeals court has to be very, very careful of how they walk here, because the precedent that would be established by allowing the state's argument here would mean that any defendant from here on out in the state of Indiana whose Franks hearings is improperly denied has no meaningful remedy. And that's heavy. That's very heavy. Franks are established for constitutional protections. Setting a precedent in which you don't have those constitutional protections because you're not allowed to have a Franks, and that if it's improperly denied, you have no remedy, it's unacceptable, and no citizen of the state of Indiana should ever allow it. Okay? Any of your politicians who support this need to be out in the next coming elections. So that covers that for you guys. That covers that. And boy, I guess it's kind of gut wrenching, you know. That one's there. It's hard to even go beyond that. I could sit here and talk another hour on that alone. Okay. Now, now we're moving. Okay, now we're going to shift again, moving on to the next section, but that was hard enough, okay? It honestly it should stop there. That this should be all that's needed in this appeal. Should not have to go any further. Reversal, remand for Franks. Anyhow, let's continue. The trial court erred. Sorry. The trial court erred by admitting Allen's confessions. The state's brief answers a case Allen is not making. It portrays this appeal as a challenge to every statement made by anyone in solitary and reframes the 13 months of pretrial maximum security solitary as ordinary disciplinary segregation. And we said that when this state's reply came out, we said that the state is very, very weakly arguing this, and they're gaslighting. This is not ordinary disciplinary segregation. This is 13 months of pretrial maximum security solitary confinement of a mentally ill man. And they treat Allen's decompensation as incidental to rather than the direct cause of his confessions. Well, that's called twisting the truth. But that's all McClelland is known for. And now we put that burden onto Todd Rokita, because Todd Rokita rubber stamped this appellate filing. Let's continue, please. That framing cannot be reconciled with the record. Allen entered IDOC, and here are the key points I'm going to highlight for you here in the highlighter. Okay? Matter of fact, let me shrink myself so you can see it. Allen entered the IDOC with pre-existing major depressive disorder and was placed on day one in the most restrictive strip cell in the most restrictive unit of a maximum security prison. For more than a year, he was recorded, caged, chained, and honestly, shocked, forcibly medicated. He lost 40 pounds. He hit his head on the cell door until he had 2 black eyes. He ate his own shit. He was tased, electrocuted, and involuntarily medicated on multiple occasions, 4 occasions total, with Haldol. He was found to be very psychotic and formally declared by medical doctors as gravely disabled. Read that paragraph for yourselves. Read that paragraph. He lost 40 pounds. He beat the shit out of himself repeatedly. He ate his own shit. He was tased. He was involuntarily medicated. He was Haldoled with long-acting Haldol on 4 separate occasions and overdosed because he had dropped 40 pounds. He was being dosed for the additional 40 pounds. He was found and declared as very psychotic and gravely disabled during this period. Meanwhile, the prosecutor waited 9 fucking days to respond to an emergency transfer motion. The prosecutor mocked the defense counsel as colorful and dramatic. And this was on the same day that Allen was found gravely disabled by doctors. And he used this delay to monitor real-time phone calls. Okay, so in other words, what's being said here, as the prosecutor is mocking and delaying, at the very same moment, Allen is being declared gravely disabled. And simultaneously, the wheels are being set in motion to instigate and monitor phone calls, collect confessions, coerce confessions, and to send in a doctor to sextort Richard Allen with cleavage, perfume, makeup, and soft voices and touches. That is not passive receipt of volunteered statements. That is active cultivation of confessions from a man the state knew was losing his mind. Read it and weep. This is very important, y'all. This is very important. This has implications for every single one of you out there, especially residents of the state of Indiana. This could be any of you or your loved ones. See it? Read it and weep. Read it and weep. Why should the state be allowed to benefit from confessions obtained under these conditions? Now we're going to move on. It gets worse. It gets worse. And like I've said before, this is Delphi. It always gets worse. It always gets worse. It only gets worse. It's Delphi. Now, if that wasn't enough to make you angry, we're going to up the ante a little because this is going to make you even more angry. And honestly, remember when I said there were specific elements in here that are highly effective that the appellate team has put together here, although the document overall is not the best. This right here is, listen to this section here. Sorry. The appellate issue is preserved because the trial court made that clear during trial. Under Rule 103B, once a court rules definitively on the record, a party not need renew an objection to preserve error for appeal. Immediately before the state called its first DOC witness, Allen's attorneys requested a sidebar to discuss the mechanics of the confession evidence and to make my objections now. Okay, look at this. To make my objections now and incorporate everything that I argued in pretrial hearings. During the sidebar, the following occurred. Okay? Mr. Razi says, so I move to incorporate those legal arguments as well. Court says, okay. And then that way, we're not making objections. Court says, I appreciate that. Razi says, okay. The court says, because you've made a great record at all of those hearings, so I think I'll grant your motion to incorporate all of those into these proceedings. Okay, so you see what took place at the sidebar? Razi says, I want to incorporate my arguments, so we're not making any objections. The court says, I appreciate that because you made a great record, so I think I'll grant the motion to incorporate all of those into proceedings. In fact, later, counsel renewed the objection to Dr. Walla's testimony based upon everything I argued before. The court confirmed it and cautioned, we do not have to beat a dead horse, okay? So see what's going on with this agreement between Razi and Judge Gull. They're agreeing that they don't have to continuously object. And she green lights this approach. So you can't use it now to say, no, you didn't object, so you didn't preserve it. You get what's being shown here? By incorporating Allen's arguments and stating the court appreciated Allen's attorney's offers to avoid objecting to each of Allen's statements, the court issued a definitive ruling and acknowledged a continuing objection. And that's your boom right there. Let me get my annoying sound effects for you guys. That's your boom right there. That's the nexus when it comes to this.
Oh my God.
Oh my God. So the court appreciated the offer to avoid objections to each of the statements. The court issued a definitive ruling acknowledging a continuing objection. Moreover, the court's admonishment to stop beating a dead horse only confirms the earlier ruling that additional objections were not necessary. Allen did not need to renew his objection during testimony. Horn v. State says a defendant does not need to object where pretrial ruling states such is unnecessary. The fact that counsel said no objection to individual exhibits after the court had thanked him for not objection and cautioned against redundancy does not constitute waiver. In Halliburton versus State, counsel made no attempt to argue or object at trial. Here, though, counsel incorporated prior arguments, renewed objections twice, and received express judicial acknowledgement. Sorry about that. Moreover, the purpose of the waiver doctrine is not to create a procedural trap, which is another key point here, because what the state is trying to do here is trap Richard Allen with this objection argument. You didn't preserve because you didn't continuously object. However, the agreement with Judge Gull was a continuing objection, and to deny that at this point in time would mean that Judge Gull created a procedural trap for Richard Allen. And the purpose of the waiver doctrine is to not create a procedural trap. So this is another, like I said, a very good section of this document right here, in my opinion. Defendant's failure to object to a final instruction in McGregor v. State did not constitute waiver, and therefore he timely objected to the instruction as a preliminary. And that is exactly what the state argument creates, a trap. When the court asks, do you object to an exhibit? An objection to the suppression issue would violate his assurance to the court that he would not object. If his attorney responds no objection, he waives an argument that he spent days making in a preliminary hearing. So it's a complicated legal argument, in my opinion, I think. But what it appears is that the court and the state here is trying to procedurally trap Richard Allen and his attorneys in this objection waiver scenario. So this is another issue that has to be a long, hard think for the appellate tribunal here. What kind of precedent do you want to establish with this procedural trap here? All right. The state does not assert that Allen's no objection denied the court the opportunity to address the issue that was significantly litigating. Allen filed a motion to suppress with a memorandum and 18 exhibits, including depositions, cell videos, body cameras, IDOC reports. The state responded in kind. The hearing lasted over 10 hours and into the next day, and the court ruled. The purposes of the objection rule were more than met, and Allen would have no strategy for wanting confessions he worked so hard in excluding to be admitted. Court should not apply waiver with unyielding rigidity when the trial court has been alerted to the issue. So you see the argument here? Okay. Now the next issue I find pretty irrelevant, but we'll just blaze through it. But I'm not really going to care about this much. The trial court erred by refusing to consider the IPAS materials that undermine every argument the state makes. The IPAS materials are part of the record as a proffer. If the trial court erred by failing to consider them, this court can correct the error by considering it on appeal. Okay. But you guys know what this is, that prolonged solitary confinement causes predictable deterioration with hallucinations, sleep disturbance, memory problems, anxiety, paranoia, depression, eating problems, or self-injury. Supply the causation link the state says is missing. Prove IDOC's knowledge of the harm and refute the state's basic needs were met. Framing. The order finds that IDOC was deliberately indifferent to the mental health needs of those inmates with serious mental illness like Allen. The state's argument that IPAS is irrelevant because the settlement from the order may have expired misses the mark. IDOC knew they had a duty to treat Allen's mental illness by moving him out of solitary because they had been successfully sued. There's no expiration on IDOC's knowledge. Okay, so what I'll say here is this is your only sentence that matters, in my opinion, which is that IDOC clearly had a duty to follow its own policy and not keep a seriously mentally ill patient, Richard Allen, in confinement, especially for 30 days and beyond, which his was 13 months. So you add up how many days that was, okay? IDOC knew what they were doing. Look, it's very clear to us all. I don't even know why we're arguing about this. It's extremely clear that John Gallipo, all right, Jerry Holman, Fran Gull, and this entire state apparatus absolutely knew what they were doing by putting Richard Allen in this hellhole, coercing confessions, and leaving him in there for 13 months. They knew it would break him. They knew it would compel him to take a plea deal or to confess to crimes which he did not commit. Okay, so we can argue semantics of this IPAS shit all day long. The fact is that the state actors in this case absolutely knew what they were doing by putting Rick Allen in Westville in solitary confinement as a seriously mentally ill pretrial detainee for over a fucking year. They knew what they were doing. It's not an accident. It wasn't happenstance. It wasn't a series of coincidences. Okay, it was intention. It was planned. It was executed perfectly, and it produced the results that they wanted, which were the confessions made during his period of psychosis and distress. Continue. The state's prolonged confinement of Allen constituted coercion, even under the law the state cites. Now here we go. You guys are going to love this one. Let me get something to annoy you with right here, because this is worthy of celebration. Let me tell you, this next section you guys are going to love. Okay, you guys are going to love this section right here. Wake the fuck up. Listen to this section one more time. Oh, come on, Prof. It was our job
to help law enforcement.
I'm legally blind.
I'm legally blind.
All right. Wake back up, because this section is what you need to hear. This is absolutely phenomenal. Hats off to Stacey Uliana, Mark Lehman for this work right here. I was waiting for this. I've been waiting for this. So this is absolutely fabulous. Listen to this. Coercive state action is not limited to police interrogation. Of course, the state argued that none of the usual hallmarks of police coercion are present because there was no traditional interrogation during these confessions. However, this is key. Colorado v. Connolly holds that coercive police activity is a necessary predicate. Okay? Not that coercion is limited to the interrogation room. And listen to these excerpts here. This is absolutely phenomenal. Townsend v. Sane. Exploitation can occur in other ways through the administration of a sedative. What is Haldol? What is Haldol? Okay. Okay. So that's the first one, right? Exploitation, coercion can occur in other ways through administration of a sedative. USA VDF, a mental health facility's reward system rendered a juvenile's confessions involuntary without traditional interrogation. So you see, state action in terms of a reward system rendered a confession or confessions involuntary even without traditional interrogation. These are precedents for Richard Allen. And it gets even better. Townsend v. Henderson. Conditions of solitary confinement themselves convey the implied threat of further punishment. See that? Conditions of solitary confinement themselves conveyed the implied threat of further punishment. And USA v. Karake, months in solitary by itself suffice to render the confessions involuntary. So, you guys seeing these precedents here, okay? Let's do it again. Exploitation can occur through administration of sedative. The reward systems in the facility can render confessions involuntary. Conditions of solitary confinement themselves convey the implied threat of further punishment. And more than anything, drum roll, months in solitary confinement by itself suffice to render confessions involuntary in USA v. Karake. That's absolutely phenomenal right there. Okay, once again. Okay, these are your precedent setting cases. So hats off for Uliana and Lehman referencing these. Again, coercive state action is not limited to police interrogation, contrary to the state's argument in this case. As law enforcement officers become more responsible and the methods used to extract confessions more sophisticated, oh my God. Duty to enforce federal constitutional protections continues. The unprecedented nature of this case does not mean that the statements were voluntary. The state failed to cite any case where it was permitted to capitalize off the psychosis that they created. Absolutely phenomenal. Absolutely phenomenal. Oh my God.
Oh my God!
Okay. State of Indiana, the microscope is on you. The world is watching. And this section right here, that again, for those of you wondering, these are pages 24 and 25. Okay, let's back it up a bit and show you. This is section C1. Coercive state action is not limited to police. Pages 24 and 25 of this appellant's reply. Absolutely phenomenal. Point number 2, the conditions of Allen's confinement were coercive. The state ignores Allen's mental health illness when arguing no coercion. There's no doubt that solitary confinement is a hallmark of coercion. Look at it. Look at it. Chambers v. Florida. Brooks v. Florida. There is zero doubt that solitary confinement is a hallmark of coercion. What it does to the mind is not contested science. It is a recognized method of breaking down human will. Davis v. Ayala. Solitary can bring a person to the edge of madness, perhaps madness itself. Recognizing scientific connection between prolonged solitary and negative psychological effects. 11 days of solitary confinement in Donald v. Myers. 11 days of solitary confinement rendered a confession involuntary, conditions that would destroy the willpower of almost any human being. Now, you guys think about it. You guys think about this. In Donald V. Myers, the precedent was set that 11 days, even only 11 days of solitary rendered a confession involuntary, conditions that would destroy the willpower of almost any human being. Here we had not only 11 days, we had 11 months and then 2 more. The state's contrary cases each involved rational defendants. In Rivera, the defendant had counsel present when he was not mentally ill. In Giles, the court found the defendant a rational person able to consider his options and make intelligent, rational choices. Here, Richard Allen was smearing feces on himself, speaking to people who weren't there, and being involuntarily medicated on the very days he confessed. World, do you see this? Do you see this, world? Do you see this? Allen was smearing feces on himself, speaking to people who weren't there, and being involuntarily medicated with severe psychotic episodes on the very days he confessed. In Kendra, the defendant spent 30 days in solitary, 1/13, 1 month in solitary, not 13. 1 month in solitary, and was not mentally ill. These cases establish a floor that Allen's case vastly exceeds. Okay, all of these above mentioned cases, sorry about that. I'm going to try to, shit. Oh, I can't do it. I'm trying to erase this. There we go. I'm taking the time to highlight this for you guys because it's that important in my mind. Okay. Patience, Prof. All right. Moving on. Okay. The state's slippery slope argument fails because Allen's confinement was unprecedentedly harsh. I don't know if that's a word, but the point is conveyed. It was unprecedented in its harshness. Allen's confinement was unprecedented. Allen was the only pretrial detainee in maximum security solitary confinement in recent history. Pretrial detainees with serious mental illnesses are housed in mental health treatment units where Allen should have been in the first place. And if you guys have been here the entire time, you know that I was arguing this the whole time, that Allen should have been in a mental health treatment unit or facility. He should have never been in Westville. Like I said, it was all intentional. Allen was constantly video monitored. Suicide companions were at his door 24/7, documenting his statements. That's why they were there. They weren't there because, see, it says even when he was not suicidal, they were there to document what he was saying, period. That's the only reason they were there. Only reason. There was no other reason. Pursuant to IDOC's own policies, any other inmate who had deteriorated like Allen would have been moved to a mental health unit. Well, why not Allen when he's a pretrial detainee? Allen was kept in solitary confinement 13 times longer than the 30-day limit. Allen's harm was both mental and physical. These are not predictable consequences of disciplinary segregation, as the state argues. They are predictable psychological pain of prolonged solitary confinement of a serious mentally ill detainee. These are the very effects that the 30-day policy exists to prevent, and they are more severe in medical and psychological damage than the conditions described in Brooks v. Florida and Donald v. Myers because they lasted not 14 days, but 13 months. Allen does not argue every statement by every restricted housing inmate must be suppressed. He argues that these conditions, in particular, imposed on him with his mental health profile over this duration, while the prosecutor actively cultivated confessions, overbore his will. Look at that phrase there. The prosecutor actively cultivated confessions. Oh my God. It's something else right here. It's really something else right here. All of you out there who don't know a thing about this case, now's the time to get caught up. Okay, now's the time to get caught up. This should never have happened to anyone. The state failed to prove that Allen's confessions were voluntary. Of course, to be expected, the state applies the wrong test and inverts the burden of proof. The state frames voluntariness as requiring outrageous or barbaric conditions. Arizona's formulation is not binding. Connolly asked whether the state engaged in coercive activity. Rogers v. Richmond asked whether the defendant's will was overborne under the totality of circumstances, a test in which mental illness plays a substantial role. The state also impermissibly shifts the burden by characterizing this as a sufficiency matter. The state bears the burden of preponderance federally beyond a reasonable doubt under the Indiana Constitution. Voluntariness is a legal question reviewed de novo. Courts must consider even uncontradicted evidence unfavorable to the verdict. The question is not whether Allen can prove coercion, it's whether the state can prove that the statements were voluntary. Okay, now that's heavy. I don't know if you guys are seeing that. Again, the question is not whether Richard Allen can prove coercion, it's whether the state can prove that the statements were voluntary. Considering the proper test with proper burden, the state failed to prove Allen's will was not overborne by his confinement. The state argues that the conditions of confinement did not cause confessions because the conditions did not become more oppressive before the confessions began, but that's bullshit, okay? Connolly only requires that the state's conduct be causally related to the confessions, and we know that in this case, the state's conduct was absolutely, not only was it causally related to the confessions, it produced the confessions. In Townsend v. Henderson, the conditions did not escalate at the moment of confession, yet the implied threat of further punishment conveyed by solitary itself vitiated free choice. Moreover, the state's argument ignores the clear connection between the duration of solitary and psychosis established in the IPAS litigation and IDOC policies limiting confinement of seriously mentally ill inmates to, drumroll, 30 days. Dr. Westcott opined that Allen's psychosis was caused by prolonged solitary acting on his pre-existing mental illness. Even Dr. Walla, the state's own witness, agreed that it was reasonable to believe that Allen's confinement caused his psychosis. Read it. Read it. Even Dr. Walla agreed that it was reasonable to believe that Richard Allen's confinement caused his psychosis. And even more concerning, Richard Allen's confessions directly correspond with his psychosis. Now look at this, y'all. Let's read this one closely. I'm going to blow it up for you. Check this out. The state's argument that Allen was mentally stable until April 13th is an absolute falsity. It's belied by the record. In March, okay, so they say April 13th, okay? Odd to have that number 13 there, isn't it? Okay. In March, Richard Allen told Dr. Walla in March that he was struggling mentally. By March 30th, he was paranoid and evasive. By April 4th, Dr. Walla described his mental health as extremely poor, critical, and deteriorating. Okay. Question for those in the back, you know, the bloodluster, demon filled, meth smoking guilters. Does April 4th come before April 13th? The state argued that Allen was stable until April 13th, but Dr. Walla on April 4th was describing his mental health as extremely poor, critical, deteriorating. By April 12th, which also comes before April 13th, he was eating his shit. Okay? By April 12th, he was eating feces and banging his head on the walls. April 12th. How was he mentally stable? Look it up here. Mentally stable until April 13th. But April 12th, he's eating his shit. Allen's attorney also noted his steep decline beginning on March 24th, which is also before April 13th. In their emergency motion, they included photographs taken before he was arrested and on April 3rd, which is also before April 13th, the day he started confessing. Look at the photographs. You see, he's 40 pounds lighter. He's slobbering all over himself. He's eating his shit. He's banging his head on the wall. He's seeing Jesus. He's thinking he's God, and if he goes to sleep, the world's going to end. He's going to start World War III. I mean, it's something else. It's something else, y'all. All right, sorry about that. I needed something to drink. All right. So we got another heavy hitter for you here. It gets even better. Good news. This is another excellent section of this document. Uh, and look, this is. Let me pull this down a minute. This is something we've withheld from you all in some aspects because we were asked to withhold this in some ways before this filing, and that's specifically regarding these phone calls. The bookend, what we now call the bookending phone calls. The phone calls which were disallowed by the judge. We've been wanting to talk about this for months and months, okay? Specifically, the content of these calls. Because if you understand the specific content of the phone call before and the phone call after this phone call containing the alleged confessions, if you understand the bookends, the context, the immediate calls before and after, you will understand that there's no way that he was not psychotic during that middle phone call, okay? Which was why it was so important to have included and admitted as evidence at trial that the jury hear. Because without the jury being able to hear this, the jury has no way to judge this phone call. But you're going to now get served up with the truth of the matter, and we can finally talk about it here. So let's take a look at this. All right. This says at 3:12 a.m. on April 3rd, Allen called his father. Now, this is where you pay attention, okay? Check this out. All right. So, the first phone call. I don't know how much longer I'm going to be lucid. He described being mentally tortured. Quote, this is in quotations. I don't know how much longer I'm going to be lucid. Mentally tortured for the last 5.5, 6 months, and feared he was being poisoned. Okay? So, first point, phone call number one. Okay? Let me wake you guys up, please. Let me wake you guys up. First point, phone call number one on April 3rd. I don't know how much longer I'm going to be lucid. He described being mentally tortured and feared he was being poisoned. Second phone call, the one that was admitted, Allen called confessing, quote unquote, to his wife. His first words were not, I did it, but I think I did it. Okay? I think I did it. And here's the kicker. The third call, the third call that bookends this, he could not remember confessing and was afraid he was losing his mind. Okay? So here's how these three phone calls go. I don't know how much longer I'm going to be lucid. I'm being mentally tortured for the last 5.5, 6 months, and I think I'm being poisoned. A few hours later, called his wife confessing, I think I did it. Next phone call, couldn't remember confessing and was afraid he was losing his mind, quote unquote. He later claims to have shot the victims. Okay? He later claimed to have shot the victims, a claim contradicted by medical evidence. We know, or at least we believe, because we don't know anything in this case, but we believe the victims were not shot. A false memory begins with a belief, and prolonged isolation is known to cause such beliefs. Likewise, Allen's psychosis did not magically end on May 3rd, right before he gives the most detailed confession to Dr. Walla. He was, in fact, involuntarily injected with Haldol 3 times in May and June. Dr. Walla admitted, and this is for the retards in the back, you know, the bloodluster guilty demons who like to say that he was just faking it. You know how these guys like to say, oh, he was faking. Well, even Dr. Walla admitted for her own self-preservation, I guess, that if somebody was just faking it, you wouldn't need to tranquilize them to get them to stop. On June 11th, he believed he was in hell. On June 20th, he was catatonic. Allen's statements expressing guilt correspond with his deep psychosis, a time he doesn't even remember. After 5.5 months in solitary, Allen lost touch with reality, questioning not only whether he was innocent or guilty, but whether he was dead or alive. And this is all factual and in the case records. As a matter of fact, everything's referenced here for your perusal. Okay? And this is truth. This is not hyperbole. This is not exaggeration. This is not made up by the defense attorneys. These are all facts on the record. Okay. And we're going to go further now. Now, this is where, when we said that the state's response was gaslighting. This is what we're referring to here. Let's read some of this. The state's alternative cause theories or speculation. And what we mean by that is the state's theories that Allen's discovery. Okay, so the state says Allen saw his discovery and he found God, and that independently caused his confessions. But that's entirely speculative and no different than arguing that a person who confessed after being beaten might have confessed anyway because he was guilty. Dr. Walla admitted that Allen's decline started before the receipt of discovery. And she never seen Allen's discovery, despite hypothesizing in a clinical note that it possibly triggered his breakdown. Even if discovery contributed to Allen's decompensation, it does not sever the state's causal contribution. A pretrial detainee does not respond to receiving legal papers by eating feces, eating his shit, ripping his mail, and writing a confession under a cell door. Allen responded that way because of the 13 months of solitary confinement, stripping him of all reserve. If anything, the discovery provided a basis for his delusions. Allen's state constitutional claim is meritorious. The state contends that Article 1, Section 14 requires the same coercive state action predicate as federal due process by pressing the very argument that the Court of Appeals already rejected in State v. Banks. In Banks, police interviewed a heavily medicated, mentally ill detainee who later did not even remember confessing. Oh, sounds familiar. Here, police collected confessions of a heavily medicated, mentally ill Allen, who later did not remember confessing. Just as law enforcement caused Banks' confession by interviewing him when they should not have, the state here caused Allen's confessions through prolonged solitary confinement. Allen's confessions were not a product of a rational intellect, but rather a psychosis caused by the state's indifference to his mental health. The state also ignores Indiana's distinctive heightened burden of beyond a reasonable doubt. Even if coercive state action were required, keeping Allen in maximum security solitary past the predictable onset of psychosis, declining him transfer against its own policy, then monitoring and collecting his statements and opposing his transfer establishes it. Okay, so you guys getting the whole? Let me back this up. You guys getting the whole picture that's being painted here? They kept him in psychosis and delayed and all this shit and in solitary past the onset of psychosis. They declined the transfer. The whole time they're monitoring and collecting his statements. He doesn't even remember to confessing. The state caused this mentally ill man to deteriorate and to fall into the psychosis through this prolonged solitary confinement, all pointing to the fact that these confessions and all of this behavior is not the product of a rational intellect, but by a psychosis that was caused by the state. Furthermore, this error was not harmless. At trial, the state called 12 witnesses, introduced 17 exhibits involving over 30 confessions. During closing, the prosecutor walked the jury through 18 of those and twice replayed Allen's phone calls. Yeah, but he didn't play the important phone calls establishing the context. In rebuttal, the prosecutor argued that Allen knew a fact only the killer would know. The state's argument that the confessions were harmless does not survive scrutiny. The trial court declined or denied Allen his right to present a complete defense, explain the scene, and impeach investigation. Okay, so you guys will remember now that now we're moving on to section 3, or point number 3 of this. A criminal defendant has a federal and state constitutional right to present a complete defense. Evidentiary rules that exclude a critical defense evidence on grounds disconnected from the rule's purpose violate that right to present a complete defense. The trial court's rulings on 7 categories of defense evidence violated that right and require. So this is about Judge Gull. Okay. Judge Gull's rulings, I'm going to interpret it for you, on 7 categories of defense evidence violated his right to present a complete defense and therefore requires reversal. The state's contrary arguments are unpersuasive. The trial court, Judge Gull, committed reversible error by excluding Blair's sketch of Bridge Guy. Now, here we're going into detail about those initial 7 points that I brought up earlier. Okay. So I'm just going to highlight them quickly and blaze through this. Sketch of Bridge Guy excluded. No eyewitness identified Allen as Bridge Guy. To prove Allen was Bridge Guy, the state rested its case on a compressed timeline where every witness needed to have seen the same person. Well, Blair did not see Allen, okay? Her sketch proves it. The issue is preserved. The state argues waiver because Allen made no offer of proof at trial. But the argument rests on abrogated case law. Since 2014, Evidence Rule 103B has provided that once a court rules definitively on the record, a party need not renew an objection or make offers of proof to preserve errors for appeal. That's a place where the prosecution gaslit you in their response, okay? That's exactly what has occurred here. The court held a hearing where the parties argued extensively whether Blair's sketch was admissible and issued a definitive ruling prohibiting the defense from using the composite sketches in the trial of this cause. There was no waiver. The sketch was relevant and not unfairly prejudicial. The state argues that the sketch was irrelevant because Blair never identified Allen as Bridge Guy. Bullshit. Okay? But the state has the logic backwards. The sketch is relevant precisely because it proves Blair never saw Allen at all. She saw this man. And this is great right here. This is who she saw. And again, the argument here is that this sketch proves Blair never saw Allen because that is not Richard Allen. Take a look at it. That is not Richard Allen. This is exculpatory evidence improperly denied by Judge Gull. Just 3 days after the murders, Blair described the man she saw on the bridge as white, approximately 20 years old, medium build with brown curly hair. At the time of the murders, Allen was 44 fucking years old, okay? Check it out. 20 years old, brown curly hair, right? Time of the murders, Allen was 44 years old with closely cropped hair. A sketch can serve as substantive evidence of innocence to prove someone else committed the crime. Blair's sketch does exactly that, which is why it is exculpatory. The state, of course, claims the sketch was unfairly prejudicial because the jury might use it to exclude Allen as Bridge Guy. Well, that's exactly what it should do. Do you see the circular arguments here? That's exactly what it should do, is exclude Allen as Bridge Guy. That's not unfair prejudice. That is the sketch's probative value. Prejudice is not unfair simply because it undermines the state's theory of the case. The state made Blair a fucking cornerstone of its identification theory, telling the jury in closing that every witness is adamant that the person they saw was Bridge Guy, with no doubt in their minds, and that Allen was on the bridge exactly where Blair saw Bridge Guy. Having built its case on Blair's observations, the state cannot simultaneously claim that what Blair observed, captured in the sketch, she rated 10 out of 10 for accuracy and declared the reliable face of Bridge Guy was too unreliable for jury to see. The state also argues the sketch was cumulative because Allen elicited Blair's verbal description on cross examination. A syllogism is not a story. Blair's description, broken into fragments by questions from lawyers, is no substitute for the sketch's persuasive force. And here's where we get to what's important for the jury. Think about this. You're judged by a jury of your peers. They are human beings. They perceive in different ways. Different things make different sense to different people. Blair's verbal description was no substitute for this sketch's persuasive force in the exculpatory direction. Only by viewing the complete image, the full face Blair drew 3 days after the murders, could the jury appreciate Allen's claims of innocence. The persuasive power of the concrete in particular is often essential to the capacity of jurors to satisfy the obligations that the law places on them. Moreover, the sketch carried probative force beyond the identification question. For 2 years, law enforcement circulated Sarah Carbaugh's sketch without an arrest. In April 2019, ISP released Blair's sketch, declared it the face of Bridge Guy, and announced Blair and Carbaugh had not seen the same person. Does anyone else out there want to bang their heads against the wall? Does this make sense? In April 2019, Indiana State Police released Betsy Blair's sketch, declaring it the face of Bridge Guy, and announced that Betsy Blair and Sarah Carbaugh did not see the same person, that they were two different people. Excuse me. Of course, though, as to be expected, after Allen's arrest, the state reversed course. The sketch placed before the jury alongside that reversal would have told the story of an investigation that changed its theory when it became convenient, and that means to railroad Richard Allen. And this is a story Betsy Blair's verbal testimony alone could never tell. Furthermore, the sketch was not hearsay, and if it was admissible. A composite sketch is a visual depiction, not a statement within the meaning of Rule 801A. It depicts rather than asserts. When courts across the country have encountered this question, they agree. The state does not dispute this and confines itself to arguing waiver, but as shown above, the issue was preserved. Even if treated as a statement, which it should not be, the sketch is still admissible on two independent grounds. First, Rule 801 D1C excludes from hearsay. Look at this is important. Rule 801 D1C excludes from hearsay a prior identification of a person made after perceiving that person, where the declarant testifies and is subject to cross examination. This rule applies to identification of a person. The drafters did not limit the identifications to identifications of defendants. The state offers no authority to the contrary. Secondly, the sketch is an adoptive admission under Rule 801D, 2, and B. The state, through the ISP, manifested adoption when it publicly released Blair's sketch in April 2019, declared it the face of Bridge Guy, and announced that Blair and Carbaugh saw different men. The state cannot formally adopt the sketch as authoritative before Allen's arrest and then bar its use at trial. And honestly, that was the thing there that absolutely drove me insane. Okay, this absolutely drove me insane when it happened. How can you do this? Let's go back to this. How can you do this? Do your switcheroo of sketches, declare the young guy as authoritative, the face of Bridge Guy, that they're two different people, and all of this that happened in the course of the past 9 years with Delphi, right? How can you do that and then come back and try to do this? You cannot formally adopt a sketch as authoritative before the arrest and then bar its use as trial because it defeats your theory and your attempt to railroad this individual. So that's a big deal. This whole section we just went through is a big deal in my view. Okay. Now, let's move on because we're going to go to another element here, which is Dr. Dawn Perlmutter. Okay. Now, this is very interesting. And again, this is something we've argued since day one, at least since the Frank's Memorandum, which we used to call, I don't know, the 130 pages or whatever it is. We all found the Frank's Memorandum extremely compelling. But let's understand why. And I'll just give you the hint now. It's because of the Click, Ferenczi, Murphy report. The trial court committed reversible error when it excluded Perlmutter's exculpatory explanation of Bridge Guy murder scene. Dr. Perlmutter holds a federal subject matter expert designation, check this out, from the U.S. government in ritualistic crime and has consulted with the FBI, DEA, and DHS. She directs the Symbol Intelligence Group, an adjunct, and is an adjunct in the forensic medical program at the Philadelphia College of Osteopathic Medicine and has authored textbooks on ritualistic homicide. She's worked dozens of ritual homicide cases and hundreds of ritualistic crimes, primarily for prosecutors. The state does not argue she was unqualified. Its argument is exclusion under Rule 403. The foundation for Perlmutter's testimony was not speculative. It was the state's own investigation. And that's what I'm saying about this Frank's Memorandum and the Ferenczi, Murphy, and Click report.
Oh my God!
It's not a defense creation. It's not speculation. It's the state's own investigation. The state relies upon Pelley, Lashbrook, and their progeny share a common premise. A defendant approaching the court with an alternative theory the prosecution has never considered, supported only by the defendant's own speculation. The concern animating the cases above, jury confusion from unmoored alternative theories, is absent in this instance. The ritual killing theory was not Richard Allen's invention. It was law enforcement's own theory, developed from the first day at the scene, pursued for years, and supported by multiple independent sources. Again, the ritualistic killing in the Delphi murders case was not the defense's own invention or speculation. It was law enforcement's own theory, developed from the first day, from day one at the scene, and pursued for several years, supported by multiple independent sources. The foundation for Perlmutter's testimony is not a defense attorney's theory. It's 5 years of law enforcement investigation, FBI consultation, and academic analysis, all pointing in the same direction. What changed was not the evidence. What changed was the arrest. When Allen was charged, the state abandoned that theory, reversed its position on the Blair and Carbaugh sketches, and recharacterized the investigation as complete and moved to exclude the evidence it had spent all prior years developing. That reversal is not a neutral evidentiary decision. It is confirmation bias made visible. In other words, law enforcement finding a more convenient suspect and retrofitting the evidence to fit him, discarding whatever pointed elsewhere. The jury was entitled to see that pivot, and the trial court's rulings ensured it never did. Now, listen to that piece. This is confirmation bias made visible. Law enforcement finding a more convenient suspect, Richard Allen, and retrofitting their evidence to fit him, discarding whatever pointed elsewhere. Hence, the 70 days of deleted shit and Reese Davis's deleted so-called uh, uh, polygraph. The jury was entitled to see the pivot, and the trial court's rulings, that means Judge Gall, ensured it never did. Boy, how perceptive. How perceptive on the point of this appellate team here. Very perceptive and very well put. The asymmetry doctrine required Perlmutter's admission, and the state fails to engage with it. The state called expert witnesses to interpret the crime scene's unusual features in an inculpatory direction. Allen was denied an expert to interpret the same features in an exculpatory direction. Indiana law has long held that the state may not use evidentiary rules as both a sword and a shield, presenting its version of contested evidence to the jury while blocking the defense from offering a contrary explanation for the same facts. Look at that. Would you look at that? That's something else right there. The state called expert witnesses to interpret the crime scene's unusual features and denied Allen's expert to interpret the same features in an exculpatory direction. The state may not use evidentiary rules as a sword and a shield, presenting its version while blocking the defense from offering a contrary explanation for the scene. And that's absolutely phenomenal. And it's what we've been saying this whole time. Okay. We've been saying this the whole time. So kudos again to this appellate team for actually putting this all in writing. The murder scene demanded an explanation that the state's theory could not provide. In fact, for those of you who haven't seen them yet, you need to go see the crime scene photos. Sticks were deliberately arranged on both girls' bodies, okay, in the form of bind runes. If you really want to know the truth, go look at the crime scene photos. You see those photos, you will never again believe a word the state says. Do you know that Jerry Holman said that the sticks were thrown in a pile on the side of their bodies? Yeah, that's what Jerry Holman tried to lie to the public and say. Believe it was at CrimeCon. Maybe Christina could correct me on that. But Jerry Holman had the audacity to say the sticks were thrown in a pile on the side of the bodies. Nope, not happening. The sticks were deliberately arranged on both girls' bodies, and that is a matter of fact. I'd actually love to show it to you. Let's see. Oh, well, there's the tree. Okay, there's a tree. Let me see if I have the sticks. Here's some of the sticks. Here's some more of the sticks. And here's a watercolor of how the bodies appeared with the sticks on top of them as they were allegedly discovered by law enforcement. So look at that. Okay, look at the disposition. Look at the photos of the actual sticks. Okay. Oh, just by coincidence, I might as well throw this up here since it's here. And look at Brad Holder's photo. Okay, but let's get back to business here. Sticks were deliberately arranged on both girls' bodies. Libby's 200-pound body was dragged several yards after death and positioned in a V formation. The girls were treated differently from each other in ways that suggest intentionality rather than impulse. The scene taken as a whole reflected a purposefulness, a deliberate, almost ceremonial quality. The state never explained this, and that sits uneasily beside the theory of a middle-aged pharmacy technician with heart problems, with no connection to the victims, no motive, no history of violence, committing a spontaneous public murder before walking home. The state argues that Perlmutter's evidence was irrelevant because motive was not a significant factor in the proof of guilt. Allen never claimed motive was important to the state's case. But motive was critical to Allen's claim of innocence because the scene suggests a motive inconsistent with Allen's guilt. A court cannot prohibit a defendant from offering evidence of an alternative motive because the state failed to present evidence of the defendant's motive. Although the state can open the door to otherwise irrelevant evidence, it cannot close the door to otherwise relevant evidence. Any challenges to the weight of Perlmutter's testimony are arguments for cross-examination, not grounds for exclusion. The trial court denied Allen his right to show the state's investigation into Bridge Guy's identity was incomplete, overlooked plausible leads, and mishandled evidence. The state claims Allen failed to establish a nexus between third-party evidence and the crime. Well, the record refutes that claim across 5 independent connections. Nexus to the victim. Abigail Williams was secretly meeting with Logan Holder, the son of Brad Holder. Again, for those in the back who act like they can't see, hear, or understand anything, let's wake you up. Nexus to the victims. Abigail Williams was secretly meeting with Logan Holder, the son of Brad Holder, the leader of a pagan group conducting rituals in Delphi every weekend. That's a direct personal connection between a named suspect and one of the murdered girls. That's a nexus established through law enforcement's own investigation, not defense speculation. That connection became more significant, not less, as Holder's account of his relationship with Abigail, quote unquote, evolved 3 times over 7 years. Nexus to the crime scene. Holder had a bind rune tattoo that was nearly identical to the stick arrangement on Abby's body. Fact. Before those details were public, Holder was posting pictures depicting dead girls with sticks placed over their bodies. That's what I just showed you. Matter of fact, Westfall told law enforcement, quote, he knew the woods near the murder scene very well. There's a nexus to the murder weapon's caliber. Holder owned a .40 caliber Smith & Wesson. Same caliber as the cartridge found between the bodies. Law enforcement never collected or tested it. The state's firearm case rests on the proposition that only Allen's gun could have produced the scene cartridge, a proposition meaningfully undermined by the existence of an uncollected .40 caliber firearm. There's another nexus through law enforcement's own conclusions. The Carroll County Sheriff connected the sticks to multiple. I'm sorry, I'm getting ahead of myself. Carroll County Sheriff connected the sticks to pagan rituals immediately. Multiple officers concluded the scene was too complex for one person. The FBI's Behavioral Analysis Unit declined to exclude ritualistic killing. A Purdue professor confirmed the stick markings were consistent with attempts to replicate Norse runic symbolism. These are the state's own pre-arrest conclusions. A nexus that law enforcement itself found compelling enough to pursue cannot be dismissed as insufficient when the defendant adopts it. Like I say, this is law enforcement's theory. There's another nexus through Holder's own admissions. Again, this is an aspect that absolutely made me want to bang my head against the wall, pull my hair out. In 2018, Holder told his wife that Patrick killed Abigail Williams with others and warned her if I talked that they would kill me. The statement is admissible as circumstantial evidence of Holder's own consciousness of guilt. A person without guilty knowledge has no reason to threaten his wife into silence about a crime he sincerely believes someone else committed. And the statement itself is joiner nexus evidence. A named alternative suspect identifying a known other alternative suspect as the killer makes it less probable that Allen committed the crime. Let's talk about that. A named alternative suspect identified by law enforcement naming another named alternative suspect by law enforcement as the killer makes it less probable that Richard Allen committed the crime. The state's nexus argument effectively requires forensic placement at the scene, DNA or physical evidence directly linking Holder or Westfall to the murders. Well, that is not the Joyner standard. Joyner requires reversal based on motive, opportunity, conduct, and a forensic hair match. Allen's evidence, victim connection, crime scene imagery, same caliber firearm, directly familiar with murder location, law enforcement, let me pull it up, own pre-arrest conclusions, and Holder's post hoc admission is a stronger multi-factor package than what Joyner found sufficient. Lashbrook distinguished Joyner on its facts. It did not establish DNA as universal prerequisite for third-party evidence in every case. Boo, 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 boo. The state's claim that police investigated and never connected Holder and Westfall to the crimes is not a response to Allen's argument. It is a restatement of the problem. The right to challenge the investigation's thoroughness would be meaningless if the investigation's own conclusions could insulate it from challenges. Listen to that one. The right to challenge the investigation, remember that's a key component of the appellate filing, is the right to, how did they phrase it? I can't remember, but the right to criticize the investigation itself, okay? The right to criticize or challenge or pick apart the state's botched investigation or the thoroughness of investigation would be meaningless if the investigation's own conclusions would insulate it from such challenge. Then there would never be such thing as impeaching. That's the word, impeaching the investigation. So in other words, the state's gaslight here is you can't impeach our investigation because our investigation never connected Holder and Westfall to the crimes. Well, it's a straw man argument. It's arguing about something that's not being argued. We are trying to debate or impeach the thoroughness of the investigation. Therefore, we have to be able to impeach the investigation. And your own conclusion that the investigation was perfect does not insulate it from challenges. Okay. Cleared in this investigation in Delphi did not mean the investigators looked and found nothing. It mean, quote, that they accepted an unverified badge swipe without watching surveillance video. It means that they never tested Holder's 40 caliber firearm against the scene cartridge. It means that they never examined Holder's phone. It means that they allowed Westfall to delete his phone data before turning it over, ignored Troopers Winter's recommendation that Holder be re-interviewed after finding Holder's social media post depicting young girls, and took 6 years to examine Westfall's flimsy alibi, only to find that it could not be confirmed. A jury that understands those very facts would have evaluated the state's cleared conclusions very differently. That is precisely why the evidence should have been admitted and why its exclusion was not harmless. The state conflates alibi accepted with alibi confirmed. Oh my God, that's a can I get a oh my God here? That's an absolute mind blower there.
Oh my God.
That's egregious. This is egregious, guys. Alibi accepted is not the same as alibi confirmed. Those are not the same thing, and the record makes the difference plain. The badge swipe occurred outside Holder's usual shift schedule. Oh my God. The badge was on a public rack accessible to any coworker with no way to detect whether Holder had swiped it himself. In fact, the human resources officer said so directly. Investigators refused to watch the surveillance video that would have resolved the question. Again, non existent evidence or deleted or disappeared or ignored. They refused to watch that video. They didn't want to know the answer to that. Westfall's alibi, accepted for 6 years without any examination, could not be confirmed when it was finally tested. These are not the hallmarks of a confirmed alibi. They are the hallmarks of a flawed investigation. The Holder Westfall ritualistic killing evidence tends to make it less probable that Richard Allen committed the crime. And the state's mishandled alibi investigation only serves to make the evidence more probative. Okay, give me a moment, please. All right, sorry, it was time for chocolate. Okay. Now we're going to get into something that, honestly, you're going to hear later. That I believe this is really important. Okay, we're getting into some really important things here. Okay, Tobin. The court committed reversible error in excluding Tobin's testimony. The state argues Tobin was unqualified because an expert in one field cannot offer opinions in another. Tobin was not asked to perform a firearms examination or opine on a field outside of his expertise. He was proffered to explain to the scientific community's critique of AFTE methodology, a subject squarely within his expertise in forensic metallurgy. As a fallback position, the state claims that Tobin's testimony went to admissibility, which is for the court rather than the jury to decide. The argument is contrary to law. Trial courts determine whether expert testimony is reliable and thus admissible. But once admitted, the jury decides whether the expert's credibility and the weight to give their testimony. Here, Tobin's testimony served both purposes. It went to the reliability and admissibility of firearms identification evidence and the credibility and the weight the jury should give Oberg's conclusions, which were exactly based on the AFTE methodology. Allen moved to exclude Oberg under 702, and the trial court denied the motion, okay? Judge Gull denied the motion without hearing. Allen then proffered Tobin to attack the weight and credibility of her opinion before the jury. The jury should have heard from Tobin. Excluding Tobin's testimony, criticizing firearm identification methodology, was reversible error. Testimony was a question of fact for the jury. Finally, the state's attempts to argue harmless error. because Allen had alternatives to impeach Oberg, but by excluding Tobin, the court stripped Allen of his chosen defense, which was that AFTE methodology is not credible science, and it's not. We all know that it's not. It's absolute bullshit junk science.
Oh my God.
But of course, this was a railroading, okay? This locked him into a narrower defense that necessarily conceded the validity of the only physical evidence against him. This prejudiced the jury against him. Allen's fallback witness, Eric Warren, is an active AFTE board member who endorses the methodology. The jury heard debate about whether Oberg applied AFTE correctly, not whether AFTE is credible. This forced substitution of Allen's chosen defense for another is not harmless and affected his constitutional right to present a defense. Once again, actually wiping our asses with the Constitution here. Okay? The court committed reversible error by excluding evidence impeaching the credibility of Allen's confessions. The solitary confinement video audio. The state argues that Allen's statements in solitary videos are hearsay because they do not facially pertain to his state of mind, and that the guard statements were also hearsay. The court should reject both arguments. Allen offered the videos, here's a kicker here, to show he was screaming, speaking incoherently, quoting scripture, singing, and making delirious statements about being King Michael, being cryogenically frozen, and starting World War III. Hello? Hello? Allen offered the audio with the video to demonstrate that he was screaming, speaking incoherently, quoting scripture, singing, making delirious statements about being King Michael, being cryogenically frozen, and starting World War III.
Oh my God.
Bruh. There is no hearsay problem when a statement is offered to prove the fact of the utterance rather than the truth of the facts asserted. Similarly, Allen proffered the staff audio to show how prison staff talked callously to him despite his obviously delirium. A statement is not hearsay when offered to show the effect on the listener. The state next invokes Sweeney v. State, claiming the audio was a self-serving attempt to enhance Allen's credibility. The state has it fucking backwards. Sweeney concerned a defendant using prior consistent statements to bolster his own testimony. Allen was doing the opposite, using his own words to show he was delusional and undermine the statements he made during solitary confinement. In other words, the confessions. He was trying to demonstrate this would have been further evidence of his true state of mind during the periods these confessions were extracted from him. Crucial evidence. And the state's fallback argument that Allen had adequate other means to impeach Dr. Walla and that psychosis is fluid ignores what the audio shows. The audio shows him clearly psychotic. The argument is not simply that Allen was psychotic on some days. The argument is that the jury needed to see and hear the specific man the state's own doctor were describing as more organized than he had been. In other words, on May 3rd, when they're describing him as more organized, we needed to hear how actually coherent was he? How psychotic was he? Of course, all of that was hidden from the jurors, like everything else in this case, all the other truth. They needed to hear it and place that clinical characterization along the April 28th video of Allen covered in feces, asking to be euthanized, claiming to be King Michael, and singing hymns. Words matter. People matter. Voices matter. Mental states matter. Without the audio, the jury watched a silent film. Without it, with it, the jury would have experienced the truth, the full scope of Alan's psychosis. The state told the jury Alan was quote unquote more organized. What the fuck does that even mean? What does that even mean? But the jury never heard what this more organized actually meant with their own ears. Remember what I said about human beings. Okay, once again, back to the April 3rd phone calls. I know we've briefly covered this. Let's get to this. We're almost done here. The April 3rd phone calls. The state played one of three calls Alan made on the morning of April 3rd, 2023. And then used Trooper fucking Harshman to characterize Alan as calm, subdued, and solemn when confessing, showing no indication of duress or stress. And this is what I was talking about. These two calls that bookend this calm, subdued, solemn confession. Okay. This is something we've wanted to talk about for so long, like I've said, and we've been unable to until tonight or today. The two calls that bookend these confessions demolish this characterization of calm, subdued, and solemn, no indication of stress. They should have been admitted under the rule of completeness, okay? Evidence Rule 106, and we're going to learn more about that a little later. The state argues the trial court permissibly excluded the bookend calls. Those cases support Allen. Librans provides that Rule 106 may be invoked to explain the admitted portion, to place it in context, to avoid misleading the trier of fact, oh my God, or to ensure a fair and impartial understanding of the admitted portion, which is exactly why this was proffered. Hawkins adds that Rule 106 is limited by fairness, and where calls are distinct and unconnected, fairness does not require their admission. In Hawkins, the defendant sought to introduce other jail calls simply because the state had played some jail calls with no internal connection to the admitted recordings. The court found no fairness basis to require their admission. In Librans, the omitted January statement was from a separate interview conducted 2 months before. Okay? This case is the opposite. The 3 April 3rd calls are not distinct conversations. They were interlinking and cross-referencing conversations within a 5.5 hour window. That's so important for you out there to realize. In the 3:12 a.m. call, 2 hours before the confession, Alan told his father he did not know how much longer I'm going to be lucid and warned, listen to this, I cannot vouch for what I would be say going forward. I don't know what I'm going to say. Okay, you guys really, really, really need to read this highlighted portion here. Alan told his father on the first call he did not know how much longer he was going to be lucid and warned that he could not vouch for what he would be saying going forward. He said, I don't know what I'm going to say. Okay? The very next phone call, 3 hours later, after he says, I don't know how much longer I'm going to be lucid. I don't know what I'm going to say. I can't vouch what I'm going to say. The very next thing he says is, I think I did it. Okay. Then, 3 hours after the confession, he asks his wife, did I call you this morning? When she said he had called, he said, I had the worst dream last night. He could not remember having confessed. Listen to that, okay? Listen to that, please. Guys, come on. All of these highlighted portions here. I'm going to point them to be annoying here. So first he says, I don't know how much longer I'm going to be lucid. I can't vouch for what I'm going to say. I don't know what I'm going to say. Okay. Then the 5 a.m. hour, he says, I think I did it. Okay. And then the 8 a.m. hour, he says, did I call you this morning? I had the worst dream last night. He's in a he's in a fantasy world. He doesn't know what's happening. This is the definition of psychosis. He's untethered from reality. Richard Allen. Fairness required their admission. Okay. This is the doctrine of completeness. Without the bookend calls, the jury heard only a confession. With them, the jury would have heard a man who warned his father that he could now not vouch for what he was about to say, and who then later could not even remember confessing and thought he had a bad dream. You guys see what's going on here with Judge Gull excluding those two bookended calls? All right. Dr. Grazian's foundation. Dr. Grazian testified that Allen suffered from delirium. When Allen asked Grazian about the observations that formed that basis, the trial court prohibited him from answering. Okay, so Dr. Grazian says Allen suffered from delirium. He's delirious. The attorneys say, can you tell us what forms your basis for that opinion? Judge Gull says, nope, can't answer that. Can't answer that. That ruling was error. Rule 703 provides that an expert may base an opinion on facts or data the expert has been aware of personally or personally observed and may testify to opinions based on inadmissible evidence, provided that it is of the type reasonably relied upon by experts in the field. Grazian reviewed phone calls, IDOC records, solitary confinement videos, and transcripts of Allen's statements, the type of material a forensic psychiatrist routinely relies upon. Rule 703 entitled him to identify specific observations from that review, including statements Allen made that were objectively false, as the clinical foundation for his diagnosis of delirium. Okay, now the state argued Allen waived this issue by failing to present Rule 703 below. The argument fails. A defendant preserves an evidentiary error by making an offer of proof, which need not be formal. An attorney's explanation of the evidence sought to be proved, it's relevant, and the answer to the objection is sufficient. At sidebar, Allen's counsel explained that Grazian was prepared to testify that his delirium opinion was based on Allen making statements clearly not consistent with the facts and patently false, including the claim that the girls were shot. So you see what's happening here? You see what's happening? Do you see why Judge Gull did not allow him to answer that question? Let's back that up. So to back this up, right here where I'm pointing, let's see if you can see where I'm pointing. You see where I'm pointing here? The trial court, I don't know if you can see that, but the trial court prohibited him from answering about the observations that formed the basis for his opinion that Allen suffered from delirium. Okay? When asked that question, the court said, nope. Judge Gull said, nope, you're not going to answer that. Why did she not allow him to answer that? Because at the sidebar, counsel explained to the judge that Grazian was prepared to testify that his delirium opinion was based on this: Allen making statements clearly not consistent with the facts and patently false, including the claim that he shot the girls. That's why Judge Gull didn't allow him to answer that damn question. The trial court was plainly appraised that Allen was offering to show the jury the observational basis for Grazian's diagnosis. That issue is preserved. Boom. Boom. Let's go to this. The data on Liberty's phone is consistent with human interaction at 5:45 p.m. Now, see, honestly, guys, this is what Andy Baldwin thought was going to be the nuclear bomb that was going to devastate this case and compel the jury uh, that to find that Richard Allen had no part in this, because they would not be able to explain why in the world this phone was interacted with at 5:45 p.m. And Andy Baldwin, unfortunately, put too much weight on this piece. Okay. But that piece is that Stacey Eldridge, a former FBI forensic analyst, found data consistent with a person interacting with Liberty German's phone at 5:45 p.m. In other words, an incoming call. Now check out this. An incoming call arrived to Libby's phone milliseconds before a wired headphone cable was inserted into the device, silencing it. Boy, that is bad. That is compelling. That is compelling information. Very compelling information. Stacey Eldridge, former FBI person, was interacting with the phone at 5:45 p.m. when Richard Allen's long gone. Matter of fact, an incoming call comes in. Milliseconds later, a wired headphone cable is inserted to the device, silencing it. That means someone else is handling that phone. The state concedes the trial court impermissibly allowed the state's witness to impeach this testimony with Google searches from anonymous troubleshooting forums. Okay? You remember the Google search, the hearsay that was admitted? The state resorts to arguing harmless error. Yeah, because that's its only go-to. That's the only go-to to try to get around this fact. They had to argue harmless error on the grounds that there was no movement and the purported interaction coincided with the height of the search for the girls. Both arguments fail. The phone showed no steps, not no movement, okay? And a person can interact with the phone without logging an interaction. Okay, that's facts. We call that factual. That is factual, y'all. Okay? Furthermore, the search begins sometime after 5 before the crime scene was located, precisely when someone with access to the phone would want to silence incoming calls. Now, think about that. That's the nexus, right? So the nexus is that just when the search is starting, precisely when someone would want to silence incoming calls, a phone call comes in and that's a wired headphone cable is inserted into it to silence it. That's former FBI forensic analyst Stacey Eldridge. It's not harmless error. The harmlessness argument misses the deeper point. The state's theory requires a single killer who committed the murders, left the scene, and was seen by Carbaugh walking west on 300 North at 3:56 p.m. But if someone was interacting with Libby's phone at 5:45 p.m. to silence an incoming call, that person was at or near the scene 2 hours after Sarah Carbaugh's sighting. A single killer cannot have been seen leaving at 3:56 and still been there at 5:45. Eldridge's finding is not a credibility dispute about phone data. It is direct evidence contradicting the state's "all witnesses saw the same person, we promise you" timeline. And they drop a bomb here, which is that Carbaugh did not see the killer leaving because the killer had not yet left. Oh my God, what a fucking bomb.
Oh my God.
Again, right here. It's direct evidence contradicting the state's "all witnesses saw the same person" timeline. Stacey Eldridge's "someone plugged that headphone jack in" at 5:45 contradicts "everybody saw Richard Allen." Carbaugh did not see a killer leaving because the killer had not yet left, if it's a single killer, because he's still messing with that phone. Without the internet forum hearsay, the jury would have had Eldridge's findings standing unchallenged. Findings that properly understood do not merely undermine the step data, but unravel the state's entire timeline. All right, y'all. And to close here, they close with the motion to correct error. The trial court committed reversible error. Okay, in denying Richard Allen's motion to correct error. Weber testified he clocked out at 2:02 and drove 20 minutes home. Okay, the state presented the arithmetic to the jury in closing. Quote, Weber got home sometime around 2:30. That's very important to understand that the state presented this time in closing. Weber got home sometime around 2:30. His van appeared on the private drive at the exact time Richard Allen would have been there with the two girls, and that was something only the killer would know. Well, the fact is that Weber was not on his private drive at any time before 2:44. His testimony was demonstrably false, and the state absolutely knew it. And if they say they didn't know it, they're fucking liars. And we know they're liars because they allowed that false testimony to ride. Not only did they allow it to ride, they reiterated, or McClellan reiterated this timeline that he knew to be false in closing arguments, thereby persuading the jury with false evidence in his closing argument. The 14th Amendment is violated when the prosecution knowingly solicits or knowingly allows it to go uncorrected. So this false testimony, which was likely with okay, let me put my personal spin on this, by the way. I would I would offer that many of the witnesses the state knowingly solicited false testimony from. Several of the witnesses the state knowingly allowed false testimony from. Just because the only fucking thing you're hearing about is Brad Weber and this motion to correct error doesn't mean that it didn't happen with the majority of the witnesses in this case. Because I guarantee you, the majority of the witnesses in this case were either allowed to present false testimony that went uncorrected, or the false testimony was solicited. And that's my take on it. Allegedly. The state claims Allen's falsity argument is predicated on an unreliable surveillance video. Well, that's bullshit. It's not so. It's predicated on the state's own FBI subject information sheet dated March 3rd, 2017, in the state's possession, which states explicitly, this is from the FBI. Weber's phone pings to parent's address overlooking crime scene initially at 2:50 p.m. Okay? The state's own FBI's subject information sheet states explicitly Weber's phone pings to parent's address overlooking crime scene initially at 2:50 p.m. That's not 2:30. The surveillance footage of Allen presented in this motion to correct error merely corroborates the approximate time window at 2:45 that indicates that Weber's testimony was knowingly false, and the state knew it to be false because this is the state's own subject information sheet from the FBI. Now, the state attempts to suggest Weber's testimony was not demonstrably false because he never testified to an exact time of arrival. Yeah, but that's misleading. Okay, that's misleading because we know McClellan specifically gave the time 2:30. Weber's testimony was false because he represented he drove directly home, not because he gave a precise arrival time. The state did not merely fail to correct the misrepresentation, it exploited it like everything else. And of course, Trooper Harshman corroborated, the expert on voice analysis who said that it's definitely Rick Allen's voice on Bridge Guy video. Yeah, he corroborated Weber's account step by step, confirming Weber's 2 p.m. clock out and testimony and testified that Weber told him in August 2024 he drove the white van straight home, which we know is a 20 to 25-minute drive, and that this absolutely fell into place with Allen's confessions. Okay, so do you see how the state colludes here or comes together to stack this narrative against Richard Allen improperly? The state converted an imprecise false statement into a precise corroboration of guilt. That's called twisting the truth to railroad Richard Allen, to exploit everything they could. You see? Now, here's an interesting one. The state claims Allen waived his Napui claim. A defendant waives Napui only if he knew the testimony was false but made no attempt to demonstrate its falsity. Allen made 6 attempts. The state obstructed every one. Here's an important series of bullet points for you guys. Please listen up. And I know it's getting long in here, but this is this is a section I'd like you to pay particularly close attention to, okay? So here we go. Wake you up. All right. Allen attempted to impeach Weber with a prior inconsistent statement. State objected. Sustained. Allen attempted to show Weber had motive to lie as an early suspect or person of interest. State objected twice, both sustained. Allen subpoenaed FBI special agent who prepared the report documenting Weber's inconsistent account. Testimony quashed at state's request. Allen attempted to elicit Weber's prior inconsistent statements through agent Christopher Goat. State objected, sustained. Allen recalled Weber directly and attempted to impeach again. State objected, sustained again. Do you guys see 6? The state solicited false testimony. Okay. False testimony that inculpated Allen, used its own officers to make testimony sound even more inculpatory, then actively resisted Allen's attempts to correct the false evidence. This was blatant Napui violation, okay? Look at him. Look at him again. The state obstructed every single one. You see? Sorry, I'm goofing again, but there we go. The errors were harmful whether considered individually or collectively. Before law enforcement ever talked with Allen, they jumped to the conclusion that Allen murdered Abby and Libby because he told Doolin in 2022 that he saw 3 girls on Freedom Trail and 4 girls thought they saw Bridge Guy on the trail. In Detective Mullen's mind, that means Allen had to be the guy the 4 girls saw and thus Bridge Guy. But Rayleigh Voorhees and her friends allege Bridge Guy sighting is uncertain evidence. The girls could have been wrong that they saw Bridge Guy. And even if they did see Bridge Guy, it does not follow that Allen has to be that guy. Regardless, law enforcement's tunnel vision focused in on Allen. When he could not remember where he parked and what he wore 5 years earlier, law enforcement pushed him to say what they wanted him to say, okay? Across 2 recorded interviews, one before his arrest, one after, Allen consistently and emphatically denied guilt. He insisted he was not Bridge Guy. He declared he never met those girls, twice repeated, "I did not murder 2 little girls," and denied 17 separate times that the casing at the scene came from his gun. Of course, to get the warrant, they ignored that Betsy Blair, the only eyewitness to the man on the bridge, described someone very different than Allen and a vehicle very different than his car. They ignored that Blair said the man Carbaugh saw was different than the man she saw. And they outright lied about Allen admitting he wore a blue jacket. They abandoned the obvious theory that more than one person did it. Something else there. That's something else, ain't it? They willy-nilly, erratically, suddenly, and without explanation, abandoned the obvious theory that more than one person did it. They ignored the oddness of the scene and the sticks on the bodies and the fact that Allen lived and worked in a community for 5 years, contacted law enforcement proactively to help, and cooperated fully. 5 days after the murders, Allen gave law enforcement the unique identifying phone numbers for the phone they now claim he was trying to hide. That's another thing for the bloodlusters. They claim Allen's trying to hide the phone. 5 days after the murders, he's giving them his phone information, including the unique IMEI identification numbers. They then confined Allen, who had never ever been arrested, in the most solitary and restrictive fucking cell in Indiana. When he predictably deteriorated, the state mocked, Nicholas McClellan mocked his attorneys concerns about his health while collecting psychosis-induced confessions. You see that? Facts, all facts. The IDOC and eventually the trial court, at the state's request, ignored the IPAS order and settlement showing that solitary confinement caused the very mental illness that the state was now exploiting. And at trial, Allen was not permitted to tell this story of tunnel vision onto the wrong man. The jury never saw the sketch of Bridge Guy that clearly is not Allen. The jury was not permitted to hear about ritualistic explanations for the crime scene, even though the state considered that for the years prior to Allen. They also could not hear about how the state failed to thoroughly investigate paganists with connections to Abby Williams and bloodletting rituals. Nor could the jury hear that the very science upon which the state was asking them to find that Allen's gun at the scene was unreliable and untrustworthy. This is especially troubling when the prosecutor argued that the state's firearm analyst had never been wrong. The jury never got to hear Allen's tangential, pressured, and delusional speech to show his confessions were not reliable, despite a parade of state's witnesses claiming he was lucid or faking. The jury was misled to believe that Allen knew a fact only the killer would know by presenting false evidence that Weber came home at a time that absolutely fell into place, 2:30, with the state's theory of when Allen would have crossed the water with the girls. Allen's conviction is based on a one-sided story. The state was permitted to build a tight timeline based on the 4 girls, Blair, Weber, the phone data, and Carbaugh, only because Allen was prohibited from impeaching each piece of evidence. His hands were tied, and his attorneys were. Even if one of these is wrong, the state's entire timeline unravels. With Allen's hands tied, the state's timeline went from superficial inference stacking, which is what I've always claimed, to quote-unquote hard facts corroborated by confessions and a firearms match. Okay, this all absolutely, unequivocally, without a doubt, misled the jury. Not only did it mislead the jury, it intentionally misled the jury. The prosecutor, the judge, the law enforcement, and the psychologist, they all collectively together, and the witnesses, misled the jury. Had the jury known all the evidence that impeached the state's timeline, firearm science, and Allen's mind at the time he was in solitary, there's more than a possibility, it's more likely than not, that the jury would have acquitted him. Okay? This is what is mean by unfair trial, no opportunity to present a defense. And the state has failed to prove beyond a reasonable doubt any one error, let alone the cumulative weight of all of them, did not contribute to the verdict. Chapman, Glossop. It has been said that a half truth masquerading as a whole truth becomes a complete untruth. Hey, that sounds familiar. Who remember when I said before paper tiger? This kind of sounds familiar too. Did someone have their hand in writing this who was not Stacy Uliano or Mark Lehman? Smells off. Smells off. Anyway, the only way our justice system works is if the jury hears the full truth. But because the jury only heard half the story, Allen was denied a fair trial. Okay? And that's your filing. Now, to close, I want to do something. Let's see if I can get this together. Okay, just a moment, please. Let's see. All right. Okay, let's see if I can handle this. What you're seeing here is an article from my Substack. I told you today that I produced a series of articles. Okay, I produced a series of articles here today at Substack, 4 articles on this particular subject matter. I want to show them to you really quickly. Some of these are pay only, so this will be a free preview for some of you who are not paid over at Substack, but 2 of them are pay only and 2 of them are free to the public. So feel free to go over to my Substack at read read the prof. Maybe a mod can put my Substack link in the chat. But so one of my articles here is called "The Appeal of Richard Allen: A Brief Summary." Okay, and it says, "I'm not a lawyer, thank God, but in reviewing the filings, here are some initial ideas that are admittedly tentative but worth noting. In the next couple of articles, I will expand on some of these ideas and dive deeper into the specific issues. If you strip away the noise, the volume, and the sheer number of arguments in this appeal, what you're left with is something much simpler and much more important. A question: did the jury hear a full, fair, and accurate version of the defense? No, because that is ultimately what appellate courts care about. Not whether every ruling was perfect, not whether every objection was preserved with surgical precision, but whether the trial taken as a whole produced a verdict we can trust. The state's response was built on 3 familiar defenses. Waiver, you didn't preserve it. Discretion, the judge had the right to exclude it. And harmless error, oh, even if it was wrong, it didn't matter. That structure is powerful on the surface, but it only holds if their claimed premise is true, that the evidence against Allen was so overwhelming that nothing excluded could have changed the outcome. This section challenges that premise by focusing on the issues that most directly undermine it, in my opinion. Okay, so let's take a look at these. Sorry about that. I'm trying to do this. So I go into the ballistic problem, why the Tobin exclusion matters. And just briefly, I say if there's a single issue that's the clearest path to reversal, it could be this one. At trial, the state leaned heavily on a 40 caliber cartridge found near the bodies, one they argued had been cycled through Allen's gun. And that piece of evidence functioned as the only physical link tying Allen directly to the crime scene. The jury heard a familiar story. The state's expert said the cartridge matched Allen's gun. The defense's expert disagreed. It was a battle of the experts. But that framing is incomplete. What the jury did not hear, because the trial court Judge Gull excluded it, was testimony from a different kind of expert entirely. Someone who doesn't just disagree with the conclusion, but challenges the validity of the entire methodology used to reach it. That distinction is everything because there are two fundamentally different questions. Did the examiner apply the method correctly? Or is the method itself scientifically reliable? The state successfully kept the jury focused only on the first question. The defense wanted to ask the second. That's where Tobin comes in. His testimony would not have been cumulative, it would have been transformative. It would have reframed the ballistic evidence from which expert do you believe to should we trust this kind of evidence at all? And that shift matters because juries tend to forgive forensic evidence enormous weight, often far more than it deserves. If the jury had been given a credible basis to doubt the entire discipline, not just its application in this case, the perceived strength of the state's physical evidence could have been changed dramatically. The state's response tries to neutralize this by arguing the judge already ruled the science admissible. Tobin's critique goes to admissibility, not weight, and he's not a firearms examiner. But this collapses an important boundary. Courts decide whether evidence can come in, but juries decide how much to trust it. And when a defense is prevented from presenting a meaningful challenge to the reliability of a key forensic method, the jury's role is greatly diminished. If there's one issue that directly threatens the state's overwhelming evidence narrative, it might be this one. The cumulative effect when a trial becomes incomplete. Appellate courts rarely reverse on a single evidentiary ruling, but they do reverse when multiple rulings, each defensible on its own, combine to distort the overall picture presented to the jury. And that's the exact problem here. That's the cumulative error problem. And in this case, it is not abstract, it is concrete. Consider what the jury did not fully see or hear: a systemic critique of the ballistics evidence, a visual representation, the sketch that could undermine identity, audio evidence reflecting Allen's mental condition, and full expert framing of how mental deterioration relates to false confessions. Each of these limitations aligns in a particular direction. Each of these. And this was the point of the railroading. They each weaken the defense's ability to challenge the state's strongest points: identity, forensics, and confessions. Of course, the state's strategy on appeal was to isolate each ruling and argue harmlessness. Even if this was wrong, it didn't matter. But that's not how juries experience trials. Jurors don't evaluate evidence in compartments, they evaluate narratives. And the defense narrative here was not simply Allen didn't do it. The defense narrative was the forensic evidence is questionable, the eyewitness picture is inconsistent, the confessions are unreliable, and the investigation may have narrowed too quickly. When key pieces of that narrative are excluded or limited, what remains is not a weakened version, it's a fundamentally altered one. That's the danger of cumulative error. Not that the jury heard less evidence, but the jury heard an entirely different story. Okay? And then I go on and I talk about some of the other issues here. Okay? So you can see here, this is all the stuff. Okay, I'll close with this. The real question for an appellate court: in the end, this appeal does not turn on whether any single ruling was clearly wrong. It turns on a more fundamental question. Did the jury hear a case where the defense was allowed to fully and fairly challenge the state's evidence? Or did it hear a version of the case where key critiques were narrowed, key visuals were removed, and key explanations were limited? If that's the answer, then the issue is not just evidentiary error, it's whether we can be confident in the verdict at all. And we can't. And that's where appellate courts, at their core, do their most important work. My answer is no, the defense was not allowed to fully and fairly challenge the state's evidence, and the jury was only able to hear a case that was extremely narrow and limited in scope, prejudiced by an overwhelmingly biased judge, and information that was unfairly skewed by the omission of exculpatory evidence and omission of evidence of a botched investigation and possible corruption by law enforcement. I think most reasonable people would agree with this when presented with all of the information. Okay? So that's my introduction to that. And let's see, I'm going to step through this really quickly. The next one is a brief summary of the brief we just read. So I'm not going to go through it exhaustively. I'll just preview it for you. It says overall assessment. The appellate brief is built as a hybrid of doctrinal argument and narrative reconstruction. It moves fluidly between constitutional frameworks and a broader theory of systemic unfairness at trial. The strength of this approach is its coherence as a story. The defense is not presenting isolated evidentiary errors, but a cumulative portrait of a trial shaped by exclusion and asymmetry. However, appellate courts do not typically absorb cases in narrative form. They tend to disaggregate issues, test each under deferential standards of review, and resist global theories unless they clearly map out onto recognized constitutional violations. In that context, the case's strongest pathway to relief is not a single dispositive claim, but a cumulative error theory supported by several close questions. The Franks challenge, evidentiary exclusions limiting the defense's case, the handling of confession-related evidence. The weaker points are those requiring proof of intent, state knowledge, or doctrinal expansion beyond established limits. And I talk about, you can see here, the search warrant and Franks challenge. Okay. I go into confessions and solitary confinement, the right to present a defense, the Napui claims, alleged false testimony, and the cumulative error theory. I'll read from here. I say, in my opinion, the most structurally important aspect of this appeal is cumulative error framing. Taken individually, many of the claims face high thresholds of deference or doctrinal limitation. Taken together, however, they form a narrative of constrained defense presentation across multiple dimensions: evidentiary exclusion, expert limitation, third-party suspect restriction, and confession contextualization. The cumulative argument is that the jury did not hear a fully adversarial presentation of alternative explanations, scientific challenges, or contextual evidence affecting confession reliability. Appellate courts are more receptive to this framing because it does not require proving that any single error was independently dispositive. Instead, it asks whether the combined effect of multiple rulings undermined confidence in the verdict. I believe that this is the most viable pathway to reversal in the case as a whole. Conclusion: the strongest appellate prospects lie in Franks-related claims, evidentiary exclusions affecting defense theory presentation, and cumulative error analysis. The weakest claims, in my opinion, seem to be those requiring proof of prosecutorial intent or constitutional expansion of the coercion doctrine. But this is by no means excludes them as important and potentially crucial elements for potential reversal. If relief is granted, I think the most likely form is not immediate suppression or outright reversal on a single issue, although we'd all like to see that and believe it'd be a just outcome, but a remand or a new trial grounded in the combined effect of multiple trial level restrictions. The overall structure of the appeal is ambitious, honest, and coherent, but its success depends on whether the appellate court engages it as a systemic fairness problem or reduces it to a series of discrete evidentiary disputes. I think that this will likely be one of the most difficult cases the Court of Appeals has seen in recent years. There are many societal and legal implications contained in this decision, and the question will be just how loyal the judges are to the state versus how loyal they might be to the justice system and Constitution as a whole. Only time will tell. Okay. Next, I go into the state's reply, the gaslight, state's brief of appellee, and you can see it here. I'm not going to read through this one. Okay. So I go through it all here, and you're welcome to go view that on your own over there at Substack. I highly recommend it. Um, let me read the closing here then. Let me see. The state's response is structurally strong in the way appellate litigation is often won through preservation arguments, deference doctrines, and harmless error framing. Its weakness is not uniform across issues, but appears most clearly where excluded evidence would have materiality or have materially altered the jury's understanding of forensic certainty, mental state evidence, or the completeness of the narrative presented at trial. Whether the conviction stands ultimately depends less on the resolution of any single evidentiary issue and more on whether the appellate court accepts the state's characterization of the record as fundamentally overwhelming, or instead views the excluded evidence as sufficiently significant to undermine confidence in the verdict as a whole. Cumulative error wins here. And by this I mean that the state's approach here was that the record of guilt was fundamentally overwhelming. My approach, though, is that the excluded evidence sufficiently undermines confidence in the verdict. So I think cumulatively, there's a stronger argument. Okay, and let me go to closing here. In this final article, I present some musings on the key reversal potentialities and give an unbiased review of the core issues. And for this one here, okay, if you look at this one, what I did with this one is I put all of these documents into Chat GPT, okay, and in order to give an unbiased picture of the reversal potentialities, I wanted to get an unbiased analysis from Chat GPT. And so I allowed Chat GPT to digest all of the documents and then spit out a list of bullet points for me on the key potentialities for reversal. Okay, the core issues. Removing all emotion from it. Because let me say this before I go further. It's very clear to all of us that there's a lot of emotions around this. We all feel a lot of emotions around this, okay? And so when we're looking at this entire thing, we tend to have emotional takes on certain issues, which is natural. And I do have my own emotional takes on all of these issues. Most concretely, my emotional takes on this whole thing center around the false confessions, okay? The treatment at Westfield, the coercion of confessions by the state actors, whether it be the other inmates who were threatening to kill him regularly, the guards that were threatening to kill him, the doctors who were mistreating him, the warden who had him in pretrial solitary confinement for 13 months. All of those issues, the deep psychosis and the taking of confessions during that period. That's where my emotions come into play and give all of that more weight. But what I decided to do is allow ChatGPT to impartially weigh all of these points and give me uh, its unbiased take. And then I transformed that list of bullet points into this narrative here that I'm about to read for you or highlight for you. I'm not going to read it entirely, but so that we could be as detached as possible from our emotions around this and look at it in the way that a truly unbiased appellate judge should have to view this. Um, because I believe that ChatGPT is going to be less biased than any of us human beings. So, upon doing that, this is what I put together. I say below is ranked an assessment of the strongest reversible issues based on my interpretation of the appellate standards, abusive discretion and prejudice, and how courts usually behave in close criminal appeals. I'm not ranking by how interesting each of these issues are. I'm ranking by what I see as a realistic reversal potential, and this is best understood as a ranking of reversible appellate risk based on how courts actually tend to treat evidentiary error claims under abusive discretion and harmless error review. In other words, the question is not what feels most important, but what is most likely to change the outcome of an appeal in this case. Okay. The core reversal landscape. Most appellate courts do not reverse on isolated evidentiary rulings unless those rulings strike at the foundation of the state's proof or collectively distort the fairness of the trial. That distinction drives everything here. The strongest arguments are therefore those that either undermine a core pillar of the state's case or accumulate into structural fairness problem. Okay. So upon all of this review in the most detached, unbiased fashion possible, the most serious reversal candidates appear in this order, in order of importance. And number one being the exclusion of Tobin and the AFTE ballistics challenge. The strongest single appellate issue is likely the exclusion of Tobin's testimony challenging the reliability of firearm and tool mark identification. What makes this different from routine expert disputes is not that it is not merely about disagreement. Is that it is not merely about disagreement with the particular examiner conclusions. It goes to the validity of the entire methodology used to connect physical evidence to the defendant. That distinction is critical in appellate terms. At trial, the jury heard a conventional expert versus expert dispute, essentially framed as competing interpretations within an accepted forensic discipline. What the defense sought to introduce was structurally different, a critique suggesting that the discipline itself may lack sufficient scientific reliability to support individual identification at the level presented by the state. Appellate courts are generally more receptive to broad cross-disciplinary critiques of forensic science than trial courts sometimes are, particularly where such evidence directly bears on the only physical link between the defendant and the crime. The prejudice argument is also unusually strong here. If the cartridge evidence is meaningfully weakened or recontextualized, it affects one of the state's central corroborating pillars. That, in turn, directly impacts the overwhelming evidence narrative that underlies the state's harmless error review. For those reasons, if there's a single issue with a realistic pathway to reversal, it's this: cumulative error. The strongest avenue is not any single ruling, but the combined effect of multiple limitations on the defense case. Okay, and I go through that, and you can see it here. Okay, now secondarily, aside from the cumulative error and the exclusion of Tobin's critique of the forensics methodology, here are some further plausible reversal arguments, exclusion of the bridge guy sketch. Okay. Most likely contributing to the cumulative error theory rather than successfully independently causing reversal. The exclusion of the sketch is important here because this would have helped the jurors evaluate the reliability of the investigative trajectory and its relevance. Okay. Another contributing factor would be the confessions or the limitations on mental state evidence. Okay. This issue centers on whether the jury received a distorted view of the defendant's psychological condition during the relevant period of the confessions. Okay. Like the sketch issue, this is more likely to matter as a part of a cumulative error analysis than as an independent basis for reversal. And I think the weakest parts here, in the most unbiased way I could possibly look at this, would be the third-party suspect evidence, okay, and the exclusion of third-party suspects. Although we believe all of the third-party suspects are viable suspects and that there is a plethora of viable evidence indicating such, much of this evidence would require a new trial in which the evidence was allowed and admitted and subsequently witnesses called, making the court's decision highly prohibitive and extremely exclusionary. Also less compelling from an impartial view is the exclusion of Perlmutter, the ritualistic killing. Again, up to the discretion of the appellate court, but more likely contributing to cumulative error. The additional phone calls, possibly contributing to the mental state above. The Weber testimony, Napui claim, possibly being decided upon favorably, requiring proof the testimony was false. It depends on how these appellate judges view that FBI subject information sheet and the pings. And the prosecutor's knowledge of that and whether or not that meant that he allowed testimony to go uncorrected. When these issues are viewed through the lens of how appellate courts usually reverse criminal convictions, this hierarchy becomes clear. The strongest reversal candidates seem to be the exclusion of Tobin's testimony and the cumulative error theory. These both engage directly with the integrity of the evidentiary foundation supporting the conviction. As I mentioned, that second tier consists of the bridge guy sketch and limitations on mental state evidence. These are meaningful, but somewhat less to independently justify reversal. However, depending on the weight the court gives these pieces, the mental state evidence with this bridge guy sketch also are more likely to produce reversal. The remaining issues, third-party suspects, ritualistic theory, Rule 106 arguments, and the Napui claim, are in practical appellate terms least likely to result in reversal on their own, but doesn't mean they won't contribute to the cumulative error. Okay, bottom line, if this case gets reversed, it will almost certainly be because the appellate court concludes the jury did not hear a full and fair challenge to the state's core evidence, specifically the ballistics and the confessions, not because of Odinism, alternative suspects, or procedural technicalities. If this case is reversed, it will almost certainly not be because of any one disputed evidentiary ruling in isolation. It will be because an appellate court or the appellate court concludes that the jury was not presented with a sufficiently complete and reliable challenge to the state's core evidentiary structure, particularly the forensic link, and confession evidence. Everything else, including alternative suspect theories and more speculative evidentiary disputes, is likely to matter only insofar as they contribute to the broader cumulative error analysis. Okay? And that, ladies and gentlemen, is sort of my takeaway in the most unbiased, level headed, uh, balanced view that I could possibly give with the tools at my disposal, not being an appellate lawyer. Okay. So that's the show for you tonight. Richard Allen's Appellant's Reply. It's a lot for one day, and it's been a long day. So I hope that all of you guys got a lot of value out of this. You got a lot to think about. Um, hey, we've got a long time now to meticulously dissect all of this and to go through and present our thoughts. This is just our introduction, and hopefully, this was meaningful to you. I do appreciate you all being here tonight. And so it's been a long day. I'm going to get some rest. I hope all of you get some rest. And we'll wake up in the morning refreshed to do it again another day. But thank you all for being here. And special thank you to my mod, Deb731. I truly appreciate the help in the chat, Deb. Love you so much. And also all of the contributors tonight to the channel, including support with Stefa. Thank you for becoming a member. David Rogers, thank you for the super sticker. MJ Lewis, 1964, thank you for the super chat. Bezo Jones, thank you for the super sticker. Truly appreciate that. Dennis McKean, super chat. There are very good point. These are very good points. No one addresses them like you do, Prof. Thank you very much, Dennis McKean. Thank you very much. That's why I come here. And Deb renewed her membership. She's been with me a long time. I truly appreciate it, Deb. And everyone for contributing to the live chat and on the comment section below on the replay. Thank you very much for your participation and your input in this channel. And in this case, as I mentioned before, everyone with the true interest and love for Libby and Abby and bringing these girls justice, and also, as I mentioned, bringing Richard Allen and his family justice, a man who truly, everyone who's encountered this case, whether it be the defense attorneys, the appellate attorneys, the private investigators, the community members at large, everyone walks away from a deep look at this case and says, Richard Allen is factually innocent. Therefore, this requires reversal. That's why this is important. And how often do you get every single attorney, every single investigator, every single knowledgeable person who's truly looked at this walking away saying, this guy is innocent? It's a lot. You compare that with all of the bloodlusters who say shit like, no, I swear I heard him say, that be a gun. Or I heard them say, that be a gun. When we've thoroughly gone through the audio on that video, and we know as a matter of fact, what was said was, this is the hill that we go down. Something as undeniable as that. There was no, this is a hill. I mean, this is the path. Okay. What was said is, this is the path that we go down, not this is the path that be a gun. But you got people out here swearing that what was said is that be a gun, when it's absolutely clear all you have to do is go look at the audio. I did it myself. I produced it for you. There's a lot here. And there are implications for years to come Like I said, the precedents that will be established by this appellate decision are enormous, and this is far from over. This is far from over. So there's a long way to go. So take care of yourselves. Okay? I'm going to take care of myself. Love you guys. Peace. See you next time. We'll be doing it soon. God bless.